With your lordship's kind leave, I was praying for leave, my lord, to move a very urgent bail application. My lord, the marriage of the youngest.
Whatever it is, file it. Tomorrow it will be listed.
My lord, only thing is, my lordship doesn't grant leave. My lord, my lord, the filing.
Leave granted. Yes.
My lord, with your lordship's kind leave, item number 855 and 856. My lord, this is on that statutory bail argument point. My lord, last week I had mentioned your lordship had indicated to come in this week to just remind your lordship.
Yes,
If a time
we repeat the same thing, Mr. Mukherjee, because every day this week matters have been fixed.
very well, my lord. Then I will again try my luck next week, my lord.
Very
I'll try my luck
Lordship,
next week.
I want to mention one matter for inclusion in the list.
Inclusion, just hand over the slip.
With the leave of my Lord Justice Banerjee, my Lord, I am mentioning one PLA matter before Justice Senior Roy Lordship.
Dada,
Lordship, this is for
inclusion. Huh?
single bench,
Excuse me.
Justice Senior Roy. Your Lordship, may I? Lordship, this.
So with your lordship's kind leave. 1 minute, 1 minute. So Friday, second up.
Right.
Okay.
Grateful.
Mention or something like that.
Grateful.
Item number 857 to 859. It has been fixed today at 12:45. Mr. Roy. Stating this matter on behalf of the prosecution. We have personally requested Mr. Basu and Mr. Mukherjee.
He's unwell. He's unwell.
He's unwell.
When? 10th.
10th.
সামনে সোমবার।
December. 9 তারিখ। December 9 তারিখ।
Decide when.
My Lord, next Monday.
Next Monday. 9th.
Calendar.
বুঝেছো কৌশিক
857 to 859.
মানডে হবে তো 12:45 12:45 next Monday.
My Lord, may I be permitted one bail matter?
Inclusion, just give it, Mr.
Not
Roy.
inclusion, my lord. After addition, your lordship asked me to come after 2 weeks.
We ask you to come after 2 weeks now. Give it. No upgradation.
My lord, kindly see the order. Kindly see the order. Your
My
lordship
lordship,
order kindly.
What will
For a
see?
moment, kindly see.
Why?
Your lordship asked that you are at liberty to renew the prayer for bail after 3 months if evidence is not closed. Only one witness was examined
Yes.
in between 5 months.
Very well. It will be taken up in due course.
Lordship, may I
Lordship, this is for non-prosecution.
To be mentioned tomorrow.
Right, Lordship.
mention the matter of relaxation of condition of bail?
Relaxation. Give it. Give it.
My lord. Item number 494 of today's list, my lord. This matter had on last week, my lord. That matter, father of the petitioner died, and your lordship asked to produce death certificate. I have produced death certificate and preparing supplementary affidavit, my lord. Can we taken up 2 p.m.? I will intimate the state council. Already have a Xerox copy of the and I am preparing the supplementary affidavit.
Come at 2 p.m.
Deep.
রাখো
For the petitioner, your lordship, I am led by Mr. Arjit Ghosh will join virtually, your lordship.
Milord, in this matter, Milord, the two matters were taken together, Milord. In this matter, two matters were together, Milord. One matter in server, one copy was server, one order copy was server, made server, Milord, other copy was not server, Milord. The last occasion, your lordship directed to me physically present my
যাচ্ছে
Yes. The similar order may be passed, Milord.
Yes, state.
Milord, I have intimated him, Milord, yesterday and today also, Milord.
How you have intimated?
Through WhatsApp, Milord, and through WhatsApp and link also I have sent to Niloy Chakraborty, Milord.
Without state's presence, sorry.
Milord, can it 2 p.m. Milord? I intimate again, Milord. Can 2 p.m. Milord?
No, not today. কালকে দিয়ে দিও আবার Yes, call the matter. Anti-bail.
একদম
Item number 1.
I'm not pressing this application.
Not present. Wonderful.
Item number 2.
But I appear for the petitioner.
Why to be mentioned?
My lord, same.
But, it is on the same footing, my lord. Your lordship has already granted bail to 3 accused
You're for the
persons.
state.
Have gone through the city same footing.
Same footing.
Let the same order be passed, lordship.
But only one indulgence, my lord. Kindly have a look at paragraph 4 at page 2 of your lordship's order. Well, at last line, if he could be permitted to stay within the jurisdiction of Kulpi police station, that is his residence. My lord.
No, that cannot be.
The young bro, old man.
He is an old man, my lord, of 71 years. Lordship kindly considers, my lord. Your lordship has held that it's just for a Durga Puja within the family, my lord.
We decide 12 kilometers away from the house of the.
And one person died.
My lord, yes, that is unfortunate.
Family matter.
That is unfortunate.
Why the family issue is,
But my lord, the houses are 12 kilometers apart.
we shall
Same
not
order.
allow.
খালি একটা পিটিশন এখানে একটা দিক ছিল সেম অর্ডার না হলে এটা না প্যারিটি করছে তো বলো The petitioner claims parity, citing an order dated November 28, 2024, passed in CRM DB 3392 of 2024, whereby other accused persons were enlarged on bail. Stop. The petitioner says that he is he stands on the same footing as those persons. Paragraph. Learned State Counsel, while opposing the prayer for bail, in her usual fairness, does not dispute that this petitioner is similarly circumstanced as the accused persons who were granted bail in CRM DB 3392 of 2024. Paragraph. Hence, on the ground of parity, we allow the petitioner's prayer. So accordingly,
I'm deeply.
ওই condition, same condition দিয়ে নিয়ে ওই orderটা থেকে।
ওনার নাম কি?
দাদা।
তো ঘুরিয়ে দিচ্ছেন কেন আমাদের?
দাদা, আমি
কথা
কিন্তু
বলে দেবেন।
state-
order দেখলাম।
হ্যাঁ,
আমাদের
হ্যাঁ।
করতে ভুলে গেলেন নাকি? Next matter, 3
Number 3. 3টা এটা 3 এর অর্ডার দাও আমাদের দিয়ে দাও ভালো হ্যাঁ হ্যাঁ কেন ছটপট করবে But co-accused, my lord, 8 months, 30 days in custody. On a last occasion, my lord, FSL report was not produced, submitted before while submission of the charge sheet. That was my ground, my lord. And my lord, thereafter,
FSL
this
submitted?
order has been passed.
When? Before filing this application was filed. Before this application was filed.
Charge sheet, FSL report was not filed.
FSL report was not filed.
That was my
Charge
point,
sheet
my
was
lord.
Filed on 17th.
No, Mr. Vishwas, FSL report as on date, has it been brought on record?
No, that is the status report which I've got.
Why we can't read? So just tell us.
But they have sent requisitions, they have made follow-ups several, but till date.
Fact please, it is not there. That's why you're not-
Definitely, your lordship.
filed along with something on 22nd.
In connection with this case, I have one of the accused has been
So
granted.
as on এখানে তো ফাইলই হয়নি আগে ওই মামলাটাই ফাইল হয়েছিল
মানে
পরে।
same-
না সেম ম্যাটার
Same matter.
same matter.
সেম ম্যাটার
Another accused. So if it was submitted,
That is.
সেম ম্যাটার
we have become so much senior that.
Charge sheet, well, charge sheet was
Same matter
submitted,
means-
but The FSL report has not been filed. That is my submission.
Well, let's
Why
say,
have you given us this order?
Because, my lord, another co-accused has been, it is my duty to bring it to your lordship's court.
You are saying the FSL is not submitted.
No,
Here it has been, please go through the para numbers.
but that is, I have not moved this application, my lord. My counterpart, another friend.
Whether you just you have to go through. You have become a senior advocate right now.
There is no recovery
Dada.
from our side.
Co-accused
Para number 2 of our order.
has been filed along with supplementary. I do not think, my lord, this is the correct.
Submission.
What do we do?
My learned friend has got a status report. Maybe on that
But,
occasion, status. It is
এটা কি অন্য কোনো মামলা?
এই মামলারই।
No, অন্য co-accused.
Hey, not today. Please sort it out and come back. We can't waste time like this.
কালকে 100 নম্বরে যাবে।
কালকে তো থাকবেই।
Recovery নেই তো।
এখানে বলছে তো ফাইল হয়ে গেছে। এখানে দেখ, এখানে
তুই just correct করে দেখে নিয়ে।
One of the case before your lordship relates to some banking transactions. Minor difference.
On the last occasion, your lordship was pleased me to satisfy your lordship in respect of the transfer of money from the
Son's account and
son's account. And my lord, I have received a report, my lord, and from the report, my lord, it is more egregious than what it seemed from superficial reading, my lord. An amount, my lord, an amount of 16,38,000, my lord, was transferred from the petitioner to his son, and an amount of rupees 60,70,000 was transferred from the son to the co-accused. And what was more egregious and glaring is that an amount of rupees 31,53,000 was deposited in cash to the bank account of the wife of the petitioner, whose nominee is the petitioner.
No, I
give
just
him a
just
copy.
giving.
Give Mr. Mukherjee a copy.
My lord,
May
I
I
just
say
share,
one?
my lord, may I complete, my lord, because
You are admitting there's all these transactions.
No, I haven't seen it as yet.
That's why I'm asking.
No, you say, let him receive
Seek
the
and
report, go
counter?
through it, my lord. But there is one thing, my lord. My lord, there is a new chapter, chapter 5A in the NDPS Act. Now, according to them, these are proceeds of crime. If I may use that word, my lord, even though that is not there in the NDPS Act, but there is a word there, illegal acquisition of property. Now, the procedure in respect of this, because 21 cannot be against me because there was no recovery of narcotic drugs.
But this is organized crime. But this is organized crime.
It's, well, your lordship, I am trying to understand
We
this.
are not on illegal acquisition of property.
Other than that, well, how can this be done?
This
What will the charge framed against me?
This-
Well, what will be the charge framed against me?
this
criminal
prima-
conspiracy, my lord.
this prima
Please,
facie
please,
would
please.
indicate your involvement in the drug peddling.
Well, that may be as a whole. Specific
Why
case
don't
has
you-
to be. Acha, let me go through the report, my lord.
Hey, you given a copy?
My lord, I've given one copy.
Report filed by the state, we kept with the records. A
There is
copy of the
also-
report has been made available
Okay, Neetush.
to learned advocate for the petitioner in court today. Paragraph, list the matter once again on Thursday. That is the usual NDPS day.
My lord,
Thursday date ta diye do.
grateful. Name this. Hey, doctor.
Next.
My lord, I'm seeking for not today.
Which one?
Item number 5.
Yes.
Last occasion also they have taken.
Huh?
The last occasion also they have taken.
Yes, my lord. My lord, due to personal grounds, my senior has not.
Completely meritless.
No.
চলো এই বসে থাকো
Grateful,
বাবা,
Your
কতটি হয়ে গেছে।
I beg to appear on behalf of the petitioner, my lord. The petitioner is in custody for a period of 1 year.
NCB.
Petitioner is in custody for a period of.
Again.
File, your lordship kindly peruse the report.
Bail objection.
তো কি কপি বেল অবজেকশন
ফেরত দিয়ে দাও, ফেরত এক্সট্রা দিন না।
কি হচ্ছে আমি বুঝতে পারছি না।
ও দুখানা বোধহয় দিন।
দুখানা আছে, দুটো ডিফারেন্ট।
Your lordship got the report, my lord?
How many reports you have filed?
Bail
No.
objection.
First, one report has been filed. Thereafter, your lordship has been pleased to direct us to, my lord, ensure about the present medical condition of the petitioner. That has been filed, my lord.
How many days he is in custody?
My lord, he is in custody 536 days.
1 year, 6 months, 1
But
year.
your lordship kindly come to page, my lord, 3 of the report. That is very vital.
Stage of the.
My lord, charge has been framed and the delay has been attributed in this case not to the prosecution but to the defense. That has been very, very elaborately stated in the report.
Show us.
Yes, your lordship kindly comes to page 3 of the report.
Bail objection report.
Yes,
Santosh Sahu.
yes. My lord, the paragraph starts, all the accused persons are misleading the facts. Your lordship got, my lord? Yes, and now kindly see the dates, my lord. Learned court has fixed a date on 39/23 for consideration of charge. But on that day, accused number 1 did not appear due to health issue. Further, on the next day, 17/11/23 for charge frame, but accused number 2 did not appear due to health issue. Then further dates 8/1/24, 2/2/24, 7/3/24, but it could not happen due to adjournment filed by defense. My lord, they are taking time on the pretext that, my lord, in a high court, a writ petition has been filed. Now that writ petition has been disposed of. Thereafter, charge has been framed. And last 2 dates, my lord, my instruction is, my lord, in one date, the father of the learned PP was ill. Adjournment was sought for, and the last date, my lord, the learned judge is not in a good, his health position is not good, my lord. That is the reason he could not sit.
How many witnesses?
In this case,
6 witnesses.
6 witnesses.
My lord, may I
Here as
Well, you
here as your
My
lordship.
lord, may I be permitted
my
to
lord,
1 minute if my lord
Yes,
friend allows
okay.
me? My lord, you kindly take table to look at first page 4 of the receipt report. Your lordship directed initially 2 things. I prayed before your lordship the petitioner's medical condition is serious. My lord, kindly page 4, your lordship will kindly take table. Bottom, my lord, as per report given from the superintendent Howrah, it was found out that Santosh Sahu is under treatment of the tuberculosis since 16 July 2024.
yes, page 4 of that same report.
তো আমাকে একটু বলতে দিন দাদা।
না, আমি জজ সাহেবকে করছি,
বলতে দিন,
দেখাচ্ছি ভাই।
বলছি তো স্যার, একটু বলছি।
My lord, the report just now which I have shown to your lordship, page 3, my learned friend is showing the next page, page 4.
Problem is, Mr. Mitro, there are 2 reports.
I understand your lordship.
Very confusing.
No, your lordship.
The report dated
kindly
30 September
apologize to me,
2024.
my lord, kindly goes through the
Report dated 30
just
September
now I have
2024.
submitted because, my lord, your lordship, yes.
Report-
Now, my lord, as per,
allow him to.
oh, very well.
Yes.
Well, kindly take time to look at page 4 of the said report, 30 September 2024.
Yes, he's undergoing treatment.
Under my lord, one thing, my lord. Now, my lord, your lordship will see the page 3, which was shown by lordship, my learned friend, my lord. They are all in custody. A2, A3, A4, 5, all are in custody. Due to health medical condition, the jail authority could not produce him. It is not their fault, my lord.
They are not their fault.
My lord,
Neither it is their fault.
my lord, kindly see, my lord, 1 year, 6 months, I have, my lord, I was admitted in the hospital, my lord.
The
For
reports, reports dated September 10, 2024. Now, upon perusing the reports dated September 10, 2024 and September 30, 2024, passed filed on behalf of Narcotics Control Bureau, we find that on several occasions the matter had to be adjourned before the learned trial court because of prayer made on behalf of the defense or non-appearance of accused persons. Stop. Non-production of accused persons. Stop. It is not the fault of the prosecution that there is some delay in progress of the trial. Stop. We find that charge has been framed on.
My lord, Charge has been framed on 22nd of July 24.
July 22nd, 2024. Stop. We are told there are 6 charge sheet named witnesses. Stop. Paragraph. In view of the commercial quantity of contraband items being involved, comma, what was seized?
88 kgs
Not
of
from me,
ganja.
my lord. I am the owner of the.
From his car.
88
Not
kgs
from
of
me, my
ganja.
lord. I am the owner of the.
Ganja.
Ganja.
Commercial quantity bracketed diye dao, 88 kgs of ganja being involved, comma, we are not inclined to enlarge the petitioner on bail, comma, at this stage. So next dismiss. Since the petitioner is in custody for quite some time, comma, we request the learned trial court to expedite the trial to the extent possible and conclude the same on an early date.
Grateful.
Preferably, my lord. Well, preferably, my lord. Preferably, if lordship kind enough to make it, preferably will date be fixed, man.
We cannot. Supreme Court has said very clearly, we cannot.
That.
Great.
Item number 7.
My lord, for the petitioner.
I'm the state, my lord, on the last question of a report, my lord. As far as the antecedents are concerned.
My lord, so for antecedent are concerned, the petitioner got acquitted, my lord. I have the copy of the judgment.
My lord, there are 2 matters. As far as I'm concerned, my lord, I have the information that they were charge sheeted. That you were charge sheeted on.
Case of no
Out of
recovery.
previous matters.
I'm in custody for 4 months, 14 days. From my position, nothing has been recovered. On the basis of co-accused statement, my name transferred.
That is submitted.
Charge sheet?
My lord, charge sheet has submitted, my lord.
So nothing.
My lord, the only thing,
Then
nothing is recovered from him. But my lord, the antecedent bail was rejected of this petitioner on the grounds, my lord, that he had antecedents.
No,
That's
but what antecedent? Have you
My lord, I
found
have.
out? Tell us.
My lord, there are 2 matters, my lord, where he has been charge sheeted.
He says he has been acquitted.
My lord,
This is the
I
copy
don't
of judgment, my lord. May I?
Issue.
But no recovery, my lord. I must confirm.
Report filed by the state be kept with the records. Paragraph. There was no recovery of contraband items from this petitioner. Stop. He has been implicated on the basis of statements made by co-accused persons. Stop. Charge sheet has been filed upon completion of investigation. Stop. The petitioner prays for bail. Stop. Paragraph. While opposing the prayer, comma, Learned State Counsel says that this petitioner has criminal antecedents. Stop. The petitioner, however, shows us that he has been acquitted in the criminal cases initiated against him. Paragraph. In view of the aforesaid, comma, we are of the opinion that the restriction in section 37 of the NDPS Act and diluted. We are inclined to allow the petitioner's prayer for bail.
My lord, the report be kept with the record.
Yes, you said so.
Grateful. Grateful.
My lordship, I am here for the petitioner. My lordship, there is no recovery from the petitioner, my lordship. And the petitioner in the custody for 1 year, 9 months.
No, my lord, he is on that trial.
My lordship, I am here for the petitioner.
So this matter
Petitioner
was
is in the
adjourned on the last
custody for
occasion.
1 year, 9 months. My
Matter
lordship, he is
was
in the
adjourned
custody.
on the last occasion because 27th and 28th November, these 2 dates were fixed for examination of PW4 and PW5. My lord, examination in chief completed. Next date is fixed on 7 December for cross-examination by defense as well as examination of PW6. Out of 9, stature. Now, in my humble opinion, my lord, trial is going on with a desirable speed.
My lordship, I need to be heard, my lordship.
15,620
There is,
bottles of
when
pencils
there
were
is,
recovered from their possession, along with 2344
my
capsules.
lordship, from my side, there is
of
no recovery in my name, my lordship. There is no recovery from my name, my lordship. There is no recovery. And most important, they have only done the chief, my lordship. They have not done the cross-examination.
When he is submitting, why you have interfered? We shall not take up the matter right now. We are seeing.
Okay, okay, my lordship, my apology, my apology, my lordship. Only I need to be heard. My apology, my lordship.
So
My
I think
apology.
you have got sufficient bail from this court, your client. Okay.
My apology, my apology, my lordship.
We are
But it was
asking.
recovered all these narcotic substance of 15,620 bottles of fentanyl.
Season list,
He's
Mr. Patel.
saying that nothing has been recovered
My
from
lord,
him.
these narcotics were recovered from the conscious possession of Uma Shankar Jadhav, the petitioner herein, Manoj Kumar, Mohammad Nizamuddin, and Guru Sohay Jadhav.
How the process of seizure was taken place? How he has been involved? How he has been entangled with this case?
My lord, seizure list probably has not been supplied to us.
No, bring it.
My lord, kindly fix it on Thursday, probably.
You have to be very careful.
Memo virus we have, but seizure list we
you have
don't
to
have.
show
It's a report that shown.
Very difficult to.
But it was recovered from their possession.
From his
My lordship, I
understand, my lord.
The list.
Recovered, non-recovered makes a huge difference. So for bail is concerned, my lord, kindly grant us 1 day time. I
Tomorrow,
will
special
produce
case, as a special case tomorrow.
Special, grateful, my lord.
Come back tomorrow at 10:30.
Okay, oblige, my lordship.
Seizure list देनी, seizure list नहीं निकलेगा, मतलब हमें तो seizure list वाली तो पड़ी।
Item number 9.
My lord, in item number 9, appearing for the petitioner number 1, rest of the petitioner are not pressing their application. My lord, my lord, 30 liters of codeine phosphate was recovered, not from me, my lord. A truck.
You are doing only in respect of petition number 1.
Pranab Shah.
All other being not pressed, rejected. Please.
30 liters of codeine phosphate. My lord, 1 year, 9 days.
That was recovered. 30,300 bottles of fentanyl.
From his position.
Joint possession. Joint possession.
No, my lord.
Page 9. Page 9.
It is.
Page 9 টা মোড়ানো আছে।
Seizure list. How long you are in custody?
1 year, 9 days.
9 days.
Trial is going on. Out of 50 charge-sheeted witness, 10 were completed. Next date is on 6th of
Oh, 10 completed. That's good. No, suffer a rejection or we give you a choice.
My lord, kindly see the truck was coming from Uttar Pradesh. I am just a laborer. I was just doing a loading, unloading. I do not know the contents of the truck.
There are also CDR.
You are coming from
Uttar Pradesh.
These are Bengali people. You are going to.
No, my lord, I was not in the truck. I was just doing loading, unloading.
That the trial judge will decide.
My lord, I am not aware of the contents of the
Chalo, issue.
delivery. Kindly, my
Peter coding.
Junior.
Kindly, my lord, I am not.
Not pressing.
No.
Just ওই তিনজনের আলাদা not pressed.
No. Are you pressing? Shall we?
Okay, my lord, I'm not pressing. Not pressing that.
Totally not press. Trial is progressing, madam. 10 out of 15 already examined. If there was no progress, we would have considered. And 30,000 bottles.
Or I'm not aware of the contents. I'm just a laborer doing the loading, unloading.
Your best. Very good. You are also appearing for state panel also, no?
Yes.
You have already here.
Item number 10.
I'm for the petitioner. On last date, we handed over. On last date, we handed over the copy of the report, and we also served copy to my learned friend.
What was seized?
Allegedly 1.922 kg of heroin. My humble submission will be, in this case, particular case, this person was completely trapped. But why I am saying this? Allegedly, this person.
Seizure list names him.
Yes.
The process of seizure, I am
9 kg
challenging
of
that.
heroin recovered from his possession.
May
They have taken one
May I
stance
place the
that
fact, lordship, that will
it
create
was
doubt
seized
in your
from
lordship.
one place, and then they were taken to police station where seizure list was prepared.
The allegation is that it was a public vehicle, it was a bus. The NCB entered into the bus. Kindly come to the.
Are you passenger?
Yes, I was the passenger in that bus. They straightway came, and my name was given in the their complaint, saying that this is Yaqub Sheikh.
So you have criminal antecedents.
No, I don't have any criminal antecedents. Now, that is why, I'm saying now, what they have done, they said we have found two independent witness. Then we have started seizure procedure, but since there was public, we stopped seizure procedure.
You are saying that you are not challenging the seizure procedure now.
That is why I'm saying, they have stopped the seizure procedure then and there. Thereafter, it was on 19 hour. Thereafter, they came to the police station. The independent witness came to the police station. The contraband was brought by them according to them. Then, why I'm saying to avoid these things, the entire seizure, this court directed the entire seizure has to be 191 days. Now, second thing I'm saying, this court, to avoid.
Kalu Sheikh.
Yes, that the entire has to be videographed.
If it is not done, then what? Seizure becomes illegal.
What I'm not saying that, seizure is at
We have heard
PS.
You. We have heard you. We are giving you a choice.
Second point, I'm saying is that
then we'll pass on merit. We'll not give you a choice again.
No, one thing I'm just pointing out, one point only. The arrest memo says, it is something Kolkata police case number 5, relates to NCB. Well, the matter relates to NCB case relates to Siliguri, and case number is 2. So, the entire thing was pre-planned, and then, I was entangled.
What do they have against you, Mr. Ghosh? Why you were picked up? To be trapped?
Political person.
No, not political. So far, my instruction goes.
Rich person.
Yes, rich person.
Of course, rich. Dealing with drugs, of course, rich.
It cuts both ways.
Chalo.
All right.
Allegedly 1.9 kgs of heroin was recovered from this petitioner.
Investigation complete.
Yes, madam.
Charge sheet filed.
Yes, madam.
Stop. The petitioner says that he has been trapped. Stop. He has no connection with the contraband item. Stop. He is in custody for 191 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. He prays for bail. Paragraph opposing the prayer, comma, learned NCB Counsel says that given the huge quantity of heroin recovered from this petitioner, and in view of the restriction in section 37 of the NDPS Act, comma, the petitioner's prayer should not be allowed. Stop. Paragraph, the petitioner sought to raise certain objections as regards the seizure process. Stop. Those are all factual aspects which he will be at liberty to thrash out before the learned trial court. Paragraph, in view of the huge quantity of heroin involved, comma,
Kindly add one line, my lord. Final complaint was filed on 20th November 2024.
Comma, we are not inclined to allow the petitioner's prayer for bail, comma, at this stage. Paragraph, however, comma, since the petitioner is in custody for about 6 months,
Actually, is 190.
191.
191 days.
About 6.5 months, comma, we request the learned trial court to expedite the trial to the extent possible and conclude the same on an early date.
My lord, I prayed for Idul, my lord, bail for on the ground on the issue of Idul Mia. My lord, on the last occasion, my learned friend submitted that since I prayed for bail and it was rejected on the 172nd day before the learned jurisdictional court, and I filed the bail application before this honorable court on the 179th day. So, my lord, I cannot get that.
This cannot be considered to be an application for statutory bail.
My lord,
This is
that
what-
was a
Show
submission.
us, we wanted you to
Lord,
show us some decisions on this.
Malad, this is the parent judgment guiding the law at the moment. Malad,
They submitted this.
Malad, he has a copy.
My lord, I
He is
know
also
it
carrying
is-
the same judgment.
My lord, I will also rely on Ravindran. My lord, it is the
Both
parent
has
judge.
to rely on this only, Malad. This paragraph 18.1.
Again, we have both have to rely on this.
Have to.
My lord,
Will
the-
also have to. Malad, the point, as my learned friend just said, is that whether 167(2) will start applying the moment the statutory period of 180 days expires. According to me, it has to expire. He has to exercise his right. It is only then, even if the application is kept, only after it expires and he exercises his right under 167, it is only then your lordship will be able to consider the factum. Here, my lord, the point is that 15th of September 2024 was the date of 180 days. He has approached the learned court below on 5th of September 2024, way before. That was turned down, and he preferred this application also before the expiry of 180 days. That is on 12th of September.
And
So
when
this is
the FSL submitted?
FSL was submitted on 24th.
3rd of October 2024.
Malad, the report, Malad, I have
3rd
the
of October
supplementary copy.
2024.
The supplementary copy is there, Malad.
3rd of October 2024.
This is the supplementary charge sheet.
180 days আগে file করে দিয়েছে।
No. It was after 180 days, but he had to exercise that right. That he failed. Malad, the point is that here the supplementary charge sheet and the FSL report both were dated after the period of 180.
When charge sheet was submitted, date please date.
Charge sheet was
29th of
submitted
June 2024.
29 June 2024. When
way before the 180 days period.
Mr. Kesri, sitting in circuit, I had the occasion to deal with this point, sitting in division bench. I forget the name of the case, but let us adjourn this. This case does not say that if you file an application on the 179th day, let us say, and after expiry of 180 days, the court cannot treat this as an application for statutory bail. Does it say so in so many words?
No.
It doesn't.
It does.
I believe I had the occasion to consider this.
Lordship will see, Malad, if
Not
we
to-
can also
not
get
to
hold
come
of
back.
the
Hey,
said order.
জলপাইগুড়ি
এটা পাঠিয়ে দিও তো, yes, জলপাইগুড়ি.
Yes.
The Advocate General appeared. It was possibly an application for cancellation of bail, but all these issues
raised.
came up.
when you have filed petition?
5th
Before
of
the learned jurisdictional court, I
পাঠিয়ে দিও।
5th of September 2024.
আমার চেম্বারে
And here before the High Court
On 12th of September, that is 179th day.
12 September here.
Yes.
12 September.
72 days হচ্ছে 5th of September এর 7-5-12 179.
হ্যাঁ. And FSL submitted when?
3rd of October 2024.
Now, according to the supplementary charge sheet, it's on 25th of September 2024.
No,
That is also beyond the. So the only point to be considered is that.
I may be wrong, but I just want to check
No,
up.
no.
Not today.
Let us all be sure about it.
এর আজকে পাঠিয়ে দিও আমার কাছে।
My lord, on normal NDPS days, Lordship.
Thursday.
Thursday.
My lord.
Grateful.
56 ফুটটার উপরে বলি 56 ফুট
দুই নিয়ে নিয়েছে কি করবি নট প্রেস করবি না মেরিটে করবি
2 years হয়ে গেছে আর কি ধরে রাখবি
নেক্সট ডেটটা কবে
27 January
27 ডিসেম্বর
ডিসেম্বর তো ছুটি স্পেশাল কোর্ট
27 January. Next.
Item number 12.
That's the I for the petition. Petitioner is a custody 2 years. Out of 11 witness, 6 were examined. 173 bottle of penicillin.
But out of,
Past application.
well, we need another 2 schedules, that is 4 months to
Last
complete the con. Well, we have.
warrant issue against the witness person. Can you see the last
Everything is
order?
there, my lord. If you
Can,
also
can we
kindly-
record that?
My lord, if I'm,
Last
I will record this because there are only 4 witnesses required. The next date is on 27th of Jan. 4 months.
warrant issue against the witness person. Can you see the last order?
The independent witnesses are examined. He has been identified on top.
You have failed to produce your own witness.
No.
Kindly see the last order.
Let us-
I
let
arrest
us-
all orders.
2 years, Mr. Basu, 2 years.
My lord, if your lordship kindly goes through it, then I have to file a.
Interim.
Interim.
Interim. Issue.
Well, let me file a report thereafter. Let me file a report. Whether his contention is correct or not.
What contention?
My lord, the prosecution has failed to produce a witness.
Unless you show us that this delay is attributable to him,
2 years.
how does it matter?
And particularly when the witness warrant has been issued.
My lord, if your lordship kindly have a look into the order sheets.
Kindly see the look
4th of June 2024, out of 10, PW6 has already been examined and discharged. I'm
Why? Yes.
now, my lord, will find that on 7th of August, 8th of August are the 2 dates, next schedule. If your lordship kindly turns down to the next.
Last page.
My lord, it's.
What
last
happened
but
on
2 pages.
7th and 8th?
My lord, that is what I'm going in. My lord, both the accused persons are absent.
Sure.
It was, they are in your custody. What do you mean absent?
Accused by Indrajit Bondhu.
My lord, they are on anticipatory bail.
No,
They are not coming.
You are.
Yes, there are 3 accused persons. The persons who are enjoying an anticipatory bail, they are not appearing before the court. But what the prosecution will do?
Please, there is an application for 317. Trial court has allowed that prayer that you can represent through your learned
My
counsel.
lord, now the next order, 8th of August.
Same, 317.
Same.
And warrant issue against.
Then where is his fault?
Warrant is accused are allowed to represent through their learned counsel.
Sir, when your lordship decide.
I am from.
The petitioner says that he is in custody for 2 years. Exactly 2 years.
Yes, my lord.
Today you were arrested on this date.
Yes, my lord.
What?
2nd December 20.
2nd December. Anniversary. 2 years. Stop. He was arrested on December 2, 2022. Stop. He has been falsely implicated. Stop. In any event, he should be enlarged on bail in view of the lack of progress, lack of sufficient progress in trial. Paragraph. Opposing the prayer, learned State Counsel says that 6 out of 11 charge sheet named witnesses have already been examined. Stop. All efforts will be made to conclude the trial on an early date. Paragraph. 2 years is a long period of time. Stop. 5 witnesses remain to be examined. Stop. It appears from records that warrant had to be issued against some of the prosecution witnesses. Stop.
Yes, my lord. Yes. Kindly see the 8 August
Stop.
order.
The last order it is.
One cannot say with any certainty that the trial will conclude on an early date. Paragraph. Without touching the merits of the case, solely on the touchstone of Article 21 of the Constitution of India, we are inclined to enlarge the petitioner on bail.
He shall remain within Malda PS.
My lord, also direct upon the
Malda PS and shall meet.
the time bound to
IC
complete the trial.
We cannot. That is the problem.
I see Malda PS once in a week until further order.
Yes, my lord.
There is a problem.
Fantastic.
Special decisions.
Deeply obliged.
Not with me.
My lord, I am for the petition. My lord, on the last occasion, I made a wrong submission before your lordship that there were 12 charge sheeted witness. My lord, it would have been 38 charge sheeted witness. And my lord, out of 38 charge sheeted witness.
38.
My lord, 38. Out of 38, my lord,
All are
8
need not be required. On last occasion, he stated the 3 are examined, but we represent 9 are examined. 8 are examined,
My
Lordship.
lord, what happened in this case? My lord,
PW9 is
the contraband
9th
was,
December.
contraband was recovered from the godown of one HON'BLE Sarkar. My lord, the vehicle was found there in the godown. My lord, the vehicle owner has been granted bail by this honorable court, Mustafa Ali. My lord, I was said to be Bappa Hawk, the driver of the vehicle. My lord, if your lordship kindly sees page, my lord, PW3 deposition, he is a member of the raiding party. My lord, stated it was no, my lord, none of the witnesses said that the contraband was recovered when I was driving the vehicle. I was found at the spot in the godown of HON'BLE Sarkar. My lord, nothing more, nothing less. Even the vehicle owner has been granted bail by this honorable
He is
court.
the driver of the said alleged vehicle. Lordship.
2 other co-accused.
There is 161 of the.
Madam, why do you all the time interrupt?
My lord, 2 other co-accused persons, my lord, from them cash amount of 4 lakh rupees and odd was recovered.
That Godown is your favorite place. You hang around there generally.
My lord, I was not found driving. My lord, even the independent witnesses did not support the prosecution case. My lord, I am in
8 out of?
38 witnesses.
33 are not need not be required.
How many will be required? Does your report mention that, madam?
No, they said all are if the case is proved, then need not be required
Special
others.
note, all witnesses noted in column number 14.
Yes, Lordship. Yes, Lordship.
I have go through.
Yes, Lordship. I am go through.
Then
But
why are you
if
saying that?
if the case is proved, Lordship, then 33 is not required. And independent witnesses say the page number 33.
We are not accusing him. We are not accusing.
Lordship.
Learned advocate for the petitioner says that he had inadvertently made a wrong submission on the last date, that 3 out of 12 charge sheet named witnesses have been examined. Stop. In fact, 8 out of
38 charge sheeted witness.
Owner has been granted bail, you are saying.
Owner of the vehicle, Mustafa, that is page 12. Page 12, owner of the vehicle. By this honorable.
He is driver of the vehicle.
vehicle.
He is the driver of the vehicle, but owner of the godown is not granted bail, Lordship. Last occasion is rejected.
Page 12.
He is driving the vehicle, Lordship. He is driving the vehicle and he is carrying it.
When it will be completed, your
my lord,
your deposition will be completed. How long you want? 12. Yes.
Speedy trial is going on,
my lord, 1 year, 4 months, 12 days. And my lord, the contraband was recovered stagnant from the godown. It was not recovered at the time when
the godown, Lordship.
yes.
The speedy trial is going on, Lordship.
It was not seized from the vehicle.
No,
from the godown.
Godown.
Vehicle was there.
Vehicle was standing there.
That is why we said there's nothing to connect the vehicle to the.
Yes, and my lord, so I was said to be the driver. My lord, no one knows whether I was driving or not.
Lordship, kindly see the page 33.
And my lord, the contraband was
Very
also
well.
161.
8 out of 38.
Yes, my lord.
In fact, charge sheet named witnesses have been examined.
What is the name? What is the name of your petitioner?
Bappa Hawk.
Paragraph. The petitioner says that he was the driver. He was the driver of a vehicle which was parked in the vicinity of the godown from where a commercial quantity of contraband items was seized. Stop. The vehicle owner, Mustafa Ali, alias Babu, has been granted bail by a coordinate bench by order dated July 24, 2024, passed in CRM NDPS 1142 of 2024. Stop.
তল্লাশি করে গোডাউনে তার পজিশন থেকে 57টি গাঁজার বস্তা আর পজিশনটা কিভাবে আসছে?
He is a, yes, Lordship. He is present on the spot, Lordship, and he is the vehicle, he is the driver of the vehicle in which vehicles he drive the contrabands.
We have considered your 161, okay?
কি বললেন? Stop. He does not stand on a worse footing than that person. Stop. He is in custody for 1 year, 4 months.
4 months, 12 days.
For 1 year, 4 months, 12 days. Stop. He prays for bail. Paragraph. Opposing the prayer, comma, learned state advocate says that there is sufficient incriminating evidence against this petitioner. Stop. 759 kilograms of ganja was seized from the accused persons. Stop. Paragraph. We have considered the facts and circumstances of the case. Stop. Nothing appears to have been recovered from the possession of this petitioner. Stop. His implication is on the basis of statements made by co-accused persons. Stop. He is in custody for a fairly long period of time. Stop. 30 more witnesses remain to be examined, as would appear from the report filed by the state today in court. Stop. There is practically no possibility of an early conclusion of the trial. Paragraph. In view of the aforesaid, comma, on merits as well as on the touchstone of Article 21 of the Constitution of India, comma, we are inclined to enlarge the petitioner on
You are
bail.
a resident of Kuchbihar.
Yes, my
Case is going on Barasat. You shall remain within the jurisdiction of Barasat.
My lord.
And shall meet the IC Barasat PS
My lord.
once in a week.
My
until further order. কুচবিহার থেকে এখানে এসে গোডাউনে পাহারা দিই।
Grateful to you.
Lordship, admittedly, nothing was recovered from my possession, but my prayer for bail was rejected twice, firstly on May 2023 and lastly on January 2024. Allegation against me as per prosecution case is the two persons, Mithilesh and Muhammad Reza, were apprehended with 309 grams of heroin. Now, one Nurul Islam was found in connection with telephonic conversation and monetary transaction with those two persons. Petitioner had
been already rejected on out of merit violation.
that is not clear from their report. Now, prosecution case is this from Nurul, I have telephonic conversation and monetary transaction, not from those persons who were apprehended.
Mr.
From
Chatterjee, we had called for a status report
This is a
because your
status
main
report, my
grievance was you are in custody for 1 year, 9 months.
Yes, my lord.
One out of 17 witnesses have been.
It is subject to correction. Also, it is given.
My lord, the 10 witnesses will out of 10.
Somebody had told us 17. That is why we recorded
Maybe my
17.
mistake, Lordship. I am tendering my
My
appeal
lord,
for that.
10 witnesses are in the charge sheet, my lord. Out of 10, 6 has already been, my lord, examined, my lord. And my lord, this petitioner had a, my lord, criminal antecedent also, my lord. Kindly see the reports.
Have you hand over copy of this?
Have you given him a copy of the report?
No, my lord.
Mr. Chatterjee, are you aware he has criminal antecedents?
My lord.
She is saying, consider.
And come back.
Lordship, 29 will come only then when there is antecedent.
Next
Otherwise,
date,
not
my lord, 2
20.
days and
Direct possession.
my lord, 2 days the date fixed for, my lord, further evidence.
Only in respect of
What can be
antecedent,
done?
Lordship knows better than me. This 29 comes.
29 grams.
Otherwise, direct possession 21.
So what is the deposition of witnesses against him?
Then I have to
Then
collect,
each and
my lord.
every time we have to mention, bring status report, bring deposition. Complete report should be before us. Otherwise, how can it be?
My lord, next, my lord, the deposition will be,
You have copies of the deposition.
Then
Give her a copy. You consider. Tell us
if there is nothing,
how far is the implication. If there is nothing against you, we can
Kindly
immediately.
assume this for
15
2 weeks.
2 weeks.
Certified copy.
6 out status report filed in court today. We kept with the records. Paragraph status report filed by the state in court today. Paragraph we see that 6 out of 10 charge sheet named witnesses have already been examined. Stop. We would like to see the depositions of those witnesses to assess as to what extent those witnesses have implicated this petitioner. Paragraph as requested by learned counsel for the parties, let this matter stand adjourned for 2 weeks and be listed again on the other date. 16 तारीख.
15, my lord, I beg apology, but I missed the brief.
No, I tell you, Lordship, this is the third time, my lord. But the first time, Jishan Iqbal Ahmed took time on the demise of his father. Last day, he told he has briefed him, and today, well, it's on 22 kilo of gaja, commercial quantity, compliance of section 52, and my lord, charge sheet submitted, evidence.
You are a senior lawyer. Your junior friend is asking for a day's accommodation because
This
he
is
has.
the third time, my lord.
Two junior.
You are junior to Mr. Mukherjee?
No, I am too junior to them.
Not today.
My lord, deep note, please.
My lord, I think but I prefer not to. This is issue of Idul Mia.
Not today.
Issue of Idul Mia. Charge sheet submitted without SFL. Charge frame without FSL.
Charge frame without SFL.
And I am in custody 1 year 10 months. I need a supplementary affidavit.
Right. When? How long?
Only not today. I have
not today.
Only not today.
You find out charge FSL. He says FSL not yet.
I followed me. Out of 15, 7 have already examined.
Without FSL report?
That I don't know. This is my notice.
Find out. Not today.
As you like.
My instruction is charge frame November 11/24.
Chalo, next.
Diploma.
I am for the state minorities.
I am led by Mr. Bishwajit Manna and I am praying for adjournment for this day.
Not today.
Much obliged.
Lord, for the petitioner. My lord, admittedly, this on is the last premature occasion, my lord, your application. lordship called for a report whether on the last 3 days trial, my lord, proceeded or not. My lord, the judge was not there, but my lord, kindly sees page 12. This is premature application, my lord. This was rejected by your lordships on 25th June 2024, and my lord, 8 months, my lord, time has been given.
And what is the development?
Development, my lord, last occasion judge is not in the chair.
After last rejection, any progress at all? No.
That report, my lord, I don't have.
You have to. 2 years, 1 month already.
My lord, 2 years, 6 months. My lord.
2 years, 6
6
months.
months. I'll leave it to your lordship.
How many have been examined?
My lord, 4
out of
8.
A. The petitioner renews his prayer for bail on the touchstone of Article 21 of the Constitution of India. Stop. He says that he is in custody for about 2 years, 6 months. Stop. 4 out of 8 charge sheet named witnesses have been examined. Stop. The trial court is vacant? No.
My lord, last occasion judge was not sitting, not vacant.
Stop. On the last date, the learned trial court was not available. Stop.
Lord, kindly record my submission. This is premature application.
Paragraph. Learned state advocate submits that this is a premature application since, while rejecting the petitioner's prayer for bail on June 25, 2024,
On 25th June, there was no witness. Not a single witness examined. Right now, 4 witnesses have been examined. So this is a development. You have failed to mention.
My lord.
There's a development of prosecution. Already 4 witnesses have been examined.
Yes, that I have said.
The initial stage, there was no witness examined. That's why you have asked. So either you have to not press or you have to reject, because shows that there is some development. Right?
There is progress. There can't say there's no progress.
On last two schedule, no witness. That is, in that case, may I come back?
Yes.
But after rejection, there was
Not
development.
pressed.
Yes. Okay. Not the recovery is only not
But the issue involved in this application is the filing of the charge sheet without the report of the forensic lab. That is the issue. But we have annexed the copy of the charge sheet.
As of date, is the FSL report
Yes, the
available?
FSL report came, my lord, after the
Filing of
his statutory application was filed
Filed before the learned trial court.
before the land.
And it was rejected by the learned trial court.
Yes.
Issue. It is not in dispute that the charge sheet was filed without the FSL report. Stop. The FSL report was brought on record by way of a supplementary charge sheet after the petitioner filed an application for statutory bail before the learned trial court upon expiry of 180 days from the date of his arrest. Stop. The learned trial court rejected the application. Stop. Hence this application. Paragraph. Learned state advocate in his usual fairness, does not dispute that the FSL report, that the charge sheet was not accompanied by the FSL report. Stop. The FSL report was filed only after the petitioner exercised his right to obtain statutory bail by filing application before the learned trial court. Paragraph. In view of the Hidao, paragraph, this bench,
I have the copies of those judgments.
yes, he is given. This bench, following a previous division bench decision in the case of Rakesh Shah versus State of West Bengal, reported at 2023 SCC Online Cal 2463, has held that a charge sheet filed without the FSL report is not a charge sheet within the meaning of the Criminal Procedure Code. Stop. Therefore, if a charge sheet is filed within 180 days without the FSL report, upon expiry of 180 days, the petitioner can claim statutory bail as of right. Paragraph. In view of the aforesaid, we have no option but to allow the present application. Just as a matter of curiosity, what was recovered?
A lot of things were recovered. Black powder,
16.588 heroin.
16.
lot of things were recovered.
Condition টা দিতে হবে একবার just a minute, just a minute. এই রেকর্ডটা দেখি একবার এখানে রিপোর্ট করতে বলছে
Where is the trial going on?
Nodia.
রিপোর্ট না
Nodia.
Nodia.
Nodia, where do you stay? Where's your residence?
I am from Murshidabad.
কৃষ্ণনগর
Nodia. Polasipara, Nodia.
You're also Nodia. Remain within Nodia.
না না
মহাপাত্র
trial is going on
রিল্যাক্সেশন ফাইল
Nodia. District Nodia.
ঠিক আছে পলাশিপাড়া প্লিজ
20 arm for this step.
Now, Lordship, kindly come to page 13 of my application. My application was ex parte rejected by the Honorable Apex Court on 23rd of August 2023. Now, I am in custody for 2 years, 10 months, more than.
Why expiry rejected?
Because none appears on behalf of the petitioner on call.
But there is a, we find no merit.
Yes, merit has been considered.
That is why I said ex parte on merit. I said ex parte on merit.
Even
Now,
you,
that is,
even you are not there.
court considered the merit.
Consider merit.
Now, that was rejected in August 2023. Till date, out of 30, only 3 witnesses has been examined.
Status.
My lord, everything is ready. I'm placing. My lord, what has happened, my lord? The investigating agency, after a due consultation of the learned public prosecutor conducting the trial, has dropped down 30 to 11. Now, my lord, already 6 has been examined, including an independent witnesses. My lord, if your lordship kindly have a look into the, I have made a chart. Since 30th of April 2024, my lord, at least 7 times the defense has taken a time. Adjournments.
Is it correct?
My lord, we have the order sheets, my lord. We will place it.
I'm asking this question.
When he
Now, my lord,
No,
Mr. Chatterjee, wait. I have not completed yet. My lord, a 231 application has been filed with an averment stating therein, first the entire chief will be completed, thereafter the crocs will be done. My lord, the learned court in session has rejected that application on the last day. Now, on the last day, a fresh vakalatnama has been filed stating that they have changed the lawyers. My lord, kindly see this strategical approach. Now,
this is illegal.
my lord, on 8th of February 2024, on 8th of February 2024, after rejections of the Honorable Apex Court, my lord, this Honorable Court was pleased to reject the application for some certain condition. My lord, page 11, if your lordship kindly go through it.
Actually, he's saying.
Copy of the report.
Yes, copy of the report.
If you want to consider or else.
No, so I will consider.
My lord, page 11 once. Page 11 once.
You've seen. Of the application.
Yes.
You've seen it. Status report filed by the state. Be kept with the records. Stop. A copy of the report has been made available to learned advocate for the petitioner, who seeks a little time to consider the same and come back. Paragraph. List this matter once again on Thursday. Thursday date ta diye dao. We will indicate our mind, Mr. Chatterjee. We may not be inclined. So keep that in mind.
Deeply.
No, Lordship, I have some submission, subject to correction. Change of advocate, if this is a ground.
No. We are not on change of advocate.
All these things are videographed nowadays.
We
They
are
are online. So this is the submission made from the state that change of advocate is there.
We are not on that.
People are hearing this. Does this kind of submission?
We are on strategical.
Please, due to change of a lawyer, on that day, evidence could not be done.
No, that is not
the time has been granted. That's my plea.
We shall consider. Come back.
Because everything nowadays are online. Everyone is listening the submission.
In spite of that.
Whatever of merit, I can admit that.
I have not even placed a very important document about this gentleman. I will place it on the next.
Yes, my lord. My lordship, as per the instruction of my senior, I am kindly praying for not today.
You are kindly praying. Very well.
Humbly praying.
Great.
Most grateful.
Not today.
Here I am appearing for the state.
Well, Lord, I think before I move this application, damage was done by your lordships. According to us, your lordship passed the right order. 18 months was given in the month of July in respect of my mother. Why rejecting the application? Now, my lord, basically, my lord, what I'm trying to impress upon your lordship, subject to corrections. My lord, there is a provision under the NDPS Act. Because nowadays, my lord, recovery is gone. So we have to think anew. We have to think
innovative way.
Huh?
In innovative way.
Yes. Because my lord, we have to
you are staying at Sidhabari, Alipurduar. What you are doing in Malda?
On a train. It was recovered in the train. Now, my lord, I just show one thing.
Yes, but Mr. Mukherjee, 18 months from July.
So it will go up to next year, December.
But you have not challenged this order.
Right. That's why I told your lordship at the first point.
Premature.
What is development? What is
My lord, charge has been framed and my lord, first witness has been examined. My lord, next date is on 7th,
My lord, may I say-
7th of December,
How
2020.
many witnesses?
My lord, 29.
29 witnesses.
29.
29.
only
My
one?
lord, so many witnesses will not be required, but since it,
Plus, how many will be required?
my lord, then, my lord, I have to get the report. My lord, 20, as,
This report.
my lord,
Only
we'll file.
one thing, one before, my lord. Just 5 minutes, give it to me. My lord. Because my lord, we are all for the accused persons. Now it's so easy for my learned junior friend. 18 months and recovered. Now, my lord, the recovery was done by RPF. Now, when it becomes a question of an RPF officer, then there has to be a state government notification. But PC is 42.
42.
42.
Yes.
Empowered by general or special order.
There are specifics. Excise, they are specified. Not RPF.
Whatever it can be, but then we can say that there is no.
Well,
they are
it's not my onus is not that. The onus is on the prosecutor to say that RPF at least. The onus is on the prosecution, not on me.
Okay, but
Number one.
That is during trial, not here right now.
Well, the whole trial vitiates.
We have to cut short the criminal trial.
Absolutely.
Which has been
may I say
has been discouraged by in several judicial decisions of the apex court.
Yes.
We cannot cut short the criminal trial.
No, I'm not saying that. You're not here to appreciate it. If the seizure is bad in law,
can I say that?
But if the seizure bad in law, because the RPF had no authority.
Can we mention here right now that seizure is?
Yes, I will give a judgment of justice. Suppose that you want charge.
Come back.
Yes, I did in so many terms. And he's granted bail on that score alone. Number one. Well, number two, well, please come to my petition. Well, the only problem is, well, we do not know this 18 years was there, then I would not have filed.
Not 18 years.
18 months.
18 months. Well, getting old, my lord. Dementia sort of.
We are not saying.
Do you really want to press this? Because we won't allow 18 months.
Well, can that 18 months be reduced?
Come back with
1 year?
Come back with the status report.
Oh.
Come back with the status report.
Well, we are paid once only.
Then what? Tell us what you want to do. We are not inclined. Yes, Mr.
No,
Gupta.
no, take 12.
Huh?
Make it 12 months.
No, we can't do that.
Well, it goes up to 25 January.
It will create
25 December.
It will create bad precedent
Yes,
for us.
we can't do this.
Then everybody will come.
Mr. Gupta, what is? Give instruction to your senior.
Not. Well, I made the point today. I've told Topodi. I made it very clear to him. Please don't give me NDPS cases. I made it very, very clear to him, Mala. God has been kind to me, Mala, financially, so I don't want any more to earn from NDPS.
What is the income tax file?
Income tax, I did. My lord, I'm an honest income tax paying to the extent of 10%.
Live stream.
Doesn't matter. Let them raid my house, my fees go up next day. Why not you just appreciate that? Grateful.
Raku.
Shall not to take one. I mean, ready ways.
Renewal application, your lordship, June reject.
From my position, nothing has been discovered. I have given my application only on one ground. That the allegation is that we have assaulted the civic volunteer. We have assaulted the civic volunteer.
And fled away.
Use the microphone, Mr. Gupta. Microphone, mic.
Allegation is that I have assaulted the civic volunteer, and his deposition has been examined, and he has stated that no specific role has been attributed against him. Kindly see that.
It's not NDPS Act.
NDPS, my lord. NDPS.
NDPS 104. What
at
is
the
the
time
offense?
of seizure,
But while at the
we
time
have
of seizure, there was a
assaulted the police official. That is the allegation. From my position, nothing has been recovered. On the basis of coactive statement, my name transferred. And so far, the allegation of assault is there. The victim has been examined, the civic volunteer, and no specific role has been
stated against me.
So what about then how you are there?
My lord, allegation when the seizure was taking place on that time, some people from the gathering came there and they.
Many have been examined.
My lord,
My lord, two has been examined already out of 8.
8.
Nothing has been seized from him.
My lord, if your losses, my lord, I do not want to trouble your losses.
Regarding the injury, you are saying that the
Yes.
injured victim has deposed.
Yes.
And he has not attributed any specific role to you.
They can speak.
What about possession?
Position from me, nothing. My lord.
Maybe not from you, but you were in the group. Na?
No.
Caesar list names him. Caesar list names him.
Yes.
Where's the Caesar
No,
list?
no, he's not.
Huh?
He just ran away during that similarly caught hold. My lord, there was a commotion, then this happened. My lord, that's why, my lord, this.
These are organized crimes, Mr. Gupta.
Yes, my lord.
My lord, kindly sees the FIR once that in a e-rickshaw, 2 persons were going on. When the police person reached there to seize the articles, on that time some villagers gathered there. That is the allegation.
Both the co-accused persons were rejected in April and June. Within 6 months, we can complete, my lord, if your lordship directs.
Yes, he names you.
But no specific role is there.
There are other
That-
witnesses. There are other witnesses to be examined. No, Mr.
injured
In
victim
June,
only.
25th June, we had rejected.
That is
We are not inclined. Issue.
So you are in the Toto. You are in the
No, I was not in the Toto. I was in the gathering when the seizure was taking place. On that time, we are in the gathering. That is the allegation.
Nothing has been recovered from him.
His involvement, my lord, while
So he was
leaving
in
the
Whether he is in the Toto,
my lord, not tot-
e-rickshaw or something like that.
while the seizure was being affected, he, along with others, not the co-accused whose player for rejected by your lordship, not in June and April, not if that will transfer everything. Because these people were involved in lifting the goods, could not, then this could be arrested, these persons could be arrested. There were injuries, and the after seeing the injuries, my lord, your lordship rejected them.
Issue. The petitioner renews his prayer for bail, which was last rejected on June 25, 2024. Stop. Raj, rejected on merits. Stop. Paragraph. There being no significant change of circumstances and seeing that trial is progressing, we are not inclined to allow this application. At this stage.
Lordship, my prayer for bail was rejected by this court on January 17, 2024. Now, I have prepared a special leave petition before the Honorable Apex Court that was withdrawn. You also will find at page 19 on February 2024. It was withdrawn.
Why you have withdrawn?
Yes.
Now, Lordship, after that, charges was framed on June 6th of May 2024. Thereafter, Lordship, out of total 11 witnesses, till date 3 witnesses has been examined. Last schedule was there on 14, 16 and 18th of November. No witness turn up. And next date is on 18, 19 and 28 December.
How long you are in there?
I am in custody for more than 1 year, 11 months.
Yes.
My lord, charge was framed on 6th of May 2024. Thereafter, my lord, in the first schedule,
charge sheet was filed when?
Charge sheet
May 31st May 2023.
and the delay due to the absconsion of the co-accused person. Thereafter, my lord, we apprehend all of them, and thereafter charge has been.
File a report.
Absconded after granting bail, they absconded
No, my lord.
from the initial stage.
From the initial stage, they are absconding. Charge sheet has been filed showing them absconded. Thereafter, they have been apprehended, and thereafter, my lord, we can frame the charge.
One
And
person was apprehended with 725 bottles of fentanyl and police is submitting charge sheet against 9.
Okay. The petitioner renews his prayer for bail, which was last rejected on January 17, 2024. Stop. He says that he is in custody for more than 1 year, 11 months. Stop. Only 3 out of 11 charge sheet named witnesses have been examined. Stop. On the ground of delay in progress of trial, he should be enlarged on bail. Paragraph, let the state file a status report on the next date. Stop. The report shall indicate how many more witnesses the state proposes to examine and the time frame within which the state expects the trial to conclude. Paragraph, next Thursday?
Thursday,
Thursday date to the other.
May I please, your lordship, my application, madam. শুরু করি। My lord, kindly come to page, my lord, 30. 29, my lord, starts FIR here, my lord. My lord.
How long you are in custody?
My lord, 5 months I am in custody. My lord, what I am trying to, my lord, canvass before your lordship, my lord, this where seizure was, my lord, was parked. No, this is not the case, my lord, from me. This is from a Godown. From the Godown, my lord, that's why, my lord, I am.
Seizure
My lord,
list,
that is the Babu Chatterjee. And on Sorabaon is on anticipatory bail, my lord. I am just canvassing that. My lord, kindly come to page 31, my lord. Page 31, my lord. 30. My lord, I'm coming one by one. Just, my lord.
You don't have so much time, sir.
My lord,
One by
just-
one, you cannot come.
Just for a second, my lord, 30 seconds, my lord, I can explain the same, my lord. My lord, kindly come to the last paragraph.
And my
No, the last paragraph.
Well, may I say this, Lord, may I? But item number 20, it arises out of the same case diary. I'm representing another co-accused person. But if your lordship is hearing this, then your lordship can hear it both together.
Mr. Vishas, let us first reject one, then we reject yours.
My lord, kindly. My lord, kindly see the Caesar, my lord. Caesar
submitted, chemical report has already been, my lord.
FSL report submitted in time.
My lord,
File with the charge sheet.
within 5 months, my lord,
It's a rare occasion.
my lord, may I say this, my lord? Your lordship.
No, we are not rejecting.
Mr. Vishas, Caesar list shows Javed Akhtar.
My lord, we are the my lord, the labor of a Godown, my lord. We are there. The person from whom the my lord, the Godown belongs to, he has been granted anticipatory bail. Another person is there, my lord. That's why, my lord, I am coming. That source information says that the Babu Chatterjee and Saurabh Brown having mobile numbers.
Godown owner has been granted anticipatory bail.
My lord,
Yes.
The Godown owner.
Yes.
that is the, my lord, this thing, my lord. That's, my lord. Page 54, my lord.
This is a rented accommodation, my lord.
That's
Rented.
Yes. And what I beseech your lordship,
And-
your lordship will
and
kindly
Caesar
one,
list shows, my lord.
the
Just
formal, the written complaint. Lordship will kindly.
What is your client's name?
My lord, Babu Chatterjee. My lord, Babu Chatterjee.
no, Saurabh.
Saurabh Aon has been granted anticipatory bail. He happens to be the owner of that Godown. Babu Chatterjee.
Godown on rain.
Yes. And Babu Chatterjee and the rest of the persons are the securities. Lordship will kindly comes to paragraph 3. It's very important. Paragraph 3 of the first written complaint. Here it is stated that after communicating the contents of the notice in the preferred language, they agreed to sign, and the entire seizure was as per section 50.
So Babu Chatterjee is a tenant.
Babu Chatterjee is a security. Monthly 8,000 rupees. Security. Lordship will kindly see the entire contraband was received from the tenanted portion. Section 50 will not apply.
Who was the tenant?
Well, they are the tenant, the accused persons.
No.
Principal Saurabh Aon, he is the person who has taken the Godown on rent. He has been granted anticipatory bail because on that ground that nothing was seized from him. And paragraph 3, if your lordship considers, these are the poor persons, scapegoats, these are the poor persons. Paragraph 3 shows Babu Chatterjee, they complied Section 50. If Supreme Court has clarified that Section 50 is not applicable when a contraband is seized from a particular rented place. It is Section 50 will only allow to a personal seizure and search. Section 50 is not applicable. I do not have the copies of 207, but as per instructions, I must say, Lordship will kindly comes to the seizure witness. There are only 2 seizure witnesses. Out of 10, please. Out of 10, there are only 2 seizure witnesses. They claim themselves to be independent seizure witness. Lordship will kindly comes to the seizure witness. I think my learned friend has given the case diary of one Mr. Taroknath Das. Now your Lordship will. Taroknath Das. Taroknath Das.
Seizure list, signature of witnesses.
Seizure list witness. Seizure list witness, the 161.
How many seizure memo?
Is there
only one memo? Seizure list.
one.
161 of Taroknath Das, Lordship will kindly come.
My lord. You ask me to go to the seizure list. That's
No, my lord. Seizure witness. 161 of the seizure witness. Kindly comes.
369 liters.
Boleni. To I'm boleni. Amar to ami jani ami ki mamla.
The original tenant has been granted bail.
Yes.
But why?
No.
And Abhilalal Sengupta also
They,
granted
from
anticipatory.
their possession, my lord, the recovery has been done.
From their position.
They were present at that point of time.
They are security guards.
Yeah.
No, not at all, my lord.
I'm the labor.
How long you are in custody?
Well, more than 5 months. Yes. Why, my lord? May I say this? My lord, we are the poor. My lord, we are the poor persons. We have been made scapegoat. The original owners.
Mr. Vishwas, you say so. Not necessarily that we believe you.
My lord, it is not about
right.
Lordship will kindly see.
All these things will be thrashed out before at the trial.
Yes, my lord.
We are at the moment. The Caesar list shows Caesar is from your client and your client. We are not inclined. 36,000 bottles of.
Well, it is not 36,000, it is 30, it is some 900 liters, but a small 100 ml of codeine phosphate. Well, what I am on to, Lordship will kindly seize. This is a planted one. Why am I saying? Lordship will kindly seize paragraph 3, section applicability of section 50. Your Lordship has granted bail. For once, your Lordship sees the 161 statement of the Caesar witness, which I am relying upon. Kindly seize. Kindly seize the 161 statement of the Lordship will kindly seize. Lordship, I know what's falling from your Lordship. Kindly seize for once.
161
Of Taroknath Das. Of Taroknath Das.
Taroknath Dasের পেজটা কত?
Now, Taroknath Das shows that the gazetted officers who were there, they were part of the raiding team. They were part of the raiding team. The entire matter is planted. The original person, Soravan, he gets anticipatory bail. We are 8,000 rupees monthly labor and security.
Why would they plant? I mean, what grudge they have against your
My lord,
client?
if it is that, my lord, what will these poor persons do? Kindly ask the investigating agency whether they have submitted any transactions. They cannot find anything. We are not responsible.
It is Soikot Day, statement of Soikot.
Kindly comes Taroknath Das.
He is the video.
Taroknath Das. Who was the statement of Taroknath Das?
Kindly sees Taroknath Das once. একটু তারকনাথ দাসটা বার করে দে। হ্যাঁ, এটা একটা short passover.
No Passover, find out we are coming back.
Taroknath.
It's not Taroknath, it is Shoykot Noshkot. Son of Taroknath, my lord. I do not have the papers, my lord.
So without, you do not have the papers.
My lord,
Then how can you?
My lord, 200 charge sheet has been submitted. I have been, a charge sheet has been submitted. 207 not complied. I have been given the names of.
How you have occasion to produce the CD?
Well, when did I produce the CD, my lord?
How then? How
Yes, from Caesar.
Well, the Caesar witness, Caesar list names the witness.
Copy?
Yes,
You are saying that you did not.
No.
Certified copy.
Caesar
list
certified copy we have.
The contents.
Lord, may I bring the original CD, my lord?
Why?
The Shoykot Noshkot statement is not there.
Yes.
In the CD.
What has he said? Why do you want to show that
He
to
has
us?
said that all the gazetted officers were a part of the rating team. So I would beseech you.
Some charge sheet.
Yes.
So we have to go through the statement. Bring statement.
My lord.
Please.
Other
Chalo.
witness statement is there.
Next.
Huh? Other Caesar witness statement. Chemical report. Oh, you.
Well, next day.
Thursday?
Item number 26, I am for the petitioner, my lord. My lord, charge sheet submitted on 181 days without FSL report, my lord. On that ground, my lord, I am paying bail.
Within 180 days.
181 days. On that same day,
supplementary charge sheet has already been filed.
charge sheet submitted without
Has been
FSL, my
accepted by
lord.
the learned court. But the Caesar was from his house.
I'm not on the point, my lord.
3
I'm on the
kg.
point.
Again, the relevant issue you will not address. Tell us when give us the dates. When was the charge sheet filed?
On 12th September 2024, my lord.
12 September.
Charge sheet submitted, my lord, before the learned trial court without
When were you
FSL.
arrested?
My lord, I was arrested
16th
16th March 2024.
16/3. Then 12/9.
Yes, my lord. Without FSL.
12/9 CS.
Yes, my lord.
And then supplementary CS.
And my lord, the supplementary.
No, next. When did you apply for statutory bail?
My lord, on that day, 12th September 2024.
Applied for statutory
Yes,
bail.
my lord, that I have annexed the order.
Charge sheet filed.
The day on which charge sheet filed, my lord, thereafter, my lord, I have filed my application for statutory bail.
Why?
Because without FSL, my lord, because it is without FSL.
When you have filed this application?
On
12/9,
12th September
12/9.
2024.
Been rejected.
On that day.
Rejected. And supplementary?
Supplementary filed on, my lord, 10/10/24.
10/10. So he had already become entitled to statutory bail according to Idul Mia. Therefore, the trial court should have granted bail. Not having done so, we'll have to. What? There's no scope for argument there. Even if 1,000 kgs of ganja was recovered from his house, there's no scope for argument, sir.
Well, true, my lord, on 29/9, the CFSL report was received. It was submitted.
Can be done.
My lord, what are there, my lord, I have just placed on
Issue.
lordship, my lord.
The petitioner was arrested on March 16, 2024. Stop. He says that charge sheet was submitted on September 12, 2024, without the FSL report. Stop. This was the 181st day after his arrest. Stop. On the same day, he applied for statutory bail since the FSL report did not accompany the charge sheet. Stop. The learned trial court rejected such application. Stop. Hence the present application. Paragraph. Learned state advocate, while opposing the bail prayer, says that the FSL report was made available to the investigating officer only on September 29, 2024. Stop. It was filed along with the supplementary charge sheet on October 10, 2024. Stop. Paragraph. Therefore, we see that the petitioner had exercised his right to statutory bail prior to the FSL report being brought on record by way of supplementary charge sheet. Stop. The learned trial court should have granted statutory bail to the petitioner going by the decision of this bench in the case of Idul Mia. Have a copy of that?
Yes, my lord, I have.
Where? Give it, give it. ওই তো এখানেই আছে শোনো ইদুল মিয়া হ্যাঁ আছে ইন সিআরএম এনডিপিএস 1359 হ্যাঁ ওই নিয়ে নিও তুমি এখান থেকে এটা কপি wherein reference was made to the case of Rakesh Shah versus State of West Bengal, reported at 2023 SCC Online Cal 2463. Stop. Paragraph in view of the aforesaid, comma, we have no option but to allow to grant statutory bail to the petitioner. अच्छा बिल देती से statutory bail अच्छा तो ठीक है ये और
My lord, I am for the petitioner, my lord. My lord, from this petitioner, 140 copies of sensitive recovered, my lord. Only one thing is that all the my lord, witnesses are police witnesses, and my lord, our fact is that the member, my lord, gazetted officer, who is the member, part of the member of the reading team, my lord. But kindly consider I'm in custody 1 year, 6 months, 5 months, 5 months, something.
Next date, 15th of January.
And
7 out of 10 examined.
7 out of 10.
Incriminating materials against
My lord, Caesar,
But kindly your lordship's order, my lord. Kindly.
Sole accused.
This regard.
It's reading party. Have you checked? Have you checked?
No, no.
Or kindly see.
No, please check. This is a factual aspect. Whether the gazetted officer was a member of the reading team.
All right, I'll check.
The petitioner says that he is in custody for
1 year, 5 months.
about 1 year, 5 months. Stop. The gazetted officer, the concerned gazetted officer, Karo, was a part of the reading team. Stop. This is contrary to the law laid down by the Honorable Supreme Court in the case of State of Rajasthan versus Paramanand and another. Citation to the Stop. First prayer or fresh prayer? Or
Fresh.
Stop. He prays for bail. Paragraph. Learned state advocate points out that 7 out of 10
My lord.
charge sheet named witnesses have been examined. Stop. However, she seeks a little time to ascertain whether the gazetted officer was a part of the raiding team.
My lord.
Paragraph. List this matter once again this Thursday or next week? Thursday. On Thursday date the other. And also consider Parmanand if it says so. Huh? This recovery was from where?
How much?
Road, open road. He was in the road and he was apprehended and seized.
No, that is from his body or
Yes.
From his body?
Body. But taken off. But he was carrying a bag, my lord. He was carrying an allen bag. It was.
Was his body searched?
no. Take instance. And in that case, gazetted officer required if a person is being searched. Or
Okay, we need.
একটা বডির মধ্যে পড়ে না একটা বডির মধ্যে পড়ে
এই
But 25 is connected to 25.
Yes. কবে যেন হলো ওটা? Thursday.
Thursday.
My time for the petitioners. Petitioners are in custody for 13 months. 24 bottles of fentanyl has been recovered from them. Charge sheet submitted on 4th of April 2024. Charge has been framed on 17th of May 2024. My lord, out of 8 witnesses, not a single witness has been examined.
How many?
8.
How many? Not a single.
Not a single witness has been examined.
You are in custody for?
My lord, 13 months.
There are two petitioners.
Huh?
Only 13 months.
There are two petitioners.
Two petitioners, my lord.
Same day they have been arrested.
My lord, from
Only 24 bottles. Nothing.
24 bottles of commercial quantity.
24 of what?
24 bottles of fentanyl.
Oh.
Codeine.
When was charge sheet filed?
Well, a charge sheet was filed
4th of April 2024.
4th of April.
And charge framed?
17th of May
17th April 2024.
17th May.
17th April.
May.
May.
April.
April, my lord.
April.
17th April.
Almost 8 months. More than 7 months gone from framing of charge. Not a single witness examined.
Well, date is fixed on 16/12/2024, 17/12/2024. This month, my lord.
Means nothing. But point is, why for 7 months no witness will be examined?
And then, my lord, I have to file a report.
File a report. Because 13 months is 1 year, 1 month.
1 year, 1 month.
The petitioner complains that the petitioners complain that they are in custody for 1 year, 1 month. Stop. Charge was framed on April 17, 2024. Stop. After that, there has been no progress at all. Stop. Not a single witness has been examined. Stop. There are how many?
8.
8 charge sheet named witnesses. Stop. On the ground of delay in progress of trial, they pray for bail. Paragraph. Let the state file a status report on the next date. Stop. The report shall indicate how many witnesses the prosecution.
Next week. Next week. 16, 17.
16/12, 17/12.
You will know. Which is the prosecution intends to examine and the time frame within which the prosecution expects the trial to conclude. Thursday? Thursday date the other?
Obliged, my lord.
My lord, I am for the petitioner.
For the state.
My lord, NDPS Act, my lord, 20 kg, 100 grams. The weighing scales are so well calibrated, my lord, that the 100 grams, my lord, makes a sea of a difference for, my lord, the accused. Because from, my lord,
easily says
no, my lord, there is something very important in this case, my lord, subject to correction by your lordships. Kindly have, my lord, the FIR that starts at page 9. Kindly come to page 10. The Suomotu complaint.
You are carrying 19 kgs of ganja. Why?
My lord, no, total is 21. No, my lord, but there is.
Asking this question to
Lordships.
You are carrying 19 kgs of gas.
It is not commercial then, my lord.
So
Then
that we will get bail.
no, the 37 goes away, my lord.
Even then you are not automatically entitled to bail. Even if
that is true. It still remains a discretion of your lordships. But since the bar under 37 is not there, my lord, usually the courts, my lord, after a year's detention, favorably consider
in custody for
almost a year, my lord, 337 days. My lord, I'll try to point out to your lordships, my lord, two very grave things. Kindly have the complaint at page 10.
Yes.
Kindly see, my lord, they are referring to the article seized. Kindly have, my lord, Roman 13, which is, my lord, one ash colored briefcase attaché, serial number 127 seized articles kept in the briefcase. My lord, serial number 127 are, my lord, the contraband, which was kept in the attaché. Now, kindly have, my lord, the last 4 lines of this page, my lord. I recovered, my lord has got it, my lord. I recovered the above noted seized articles which were kept in the dicky of the said car. The car driver Mahadev Shah was coming through his car, was requested to give them lift to Manikchok Ghat. Then Mahadev in good faith allowed them along with their briefcase and school bag to board the car. So my lord, the case of the prosecution is that vehicle was coming which was being driven by Mahadev. I was a passenger in that car. Vehicle was intercepted. From the dicky, the briefcase was recovered. Now, my lord, kindly, your lordship will be, my lord, shocked that, my lord, in the next page, your lordship will find at page 11, penultimate paragraph, the driver of the car, so and so, Mahadev, was interrogated and he stated that he was coming to Manikchok from Rodbari, while the above noted persons asked him for a lift up to Manikchok, and on good faith, Mahadev allowed him to both to board on the car for their journey. Now, Mahadev is being believed as gospel truth, my lord, by the investigating agency. So much so, at page 12, my lord will find Mahadev is being made a witness to the seizure list. The person who was driving the car, he was in control of the car. From his car's dicky, my lord, gaja has been allegedly recovered, and he is being made a witness. Kindly see, he is the third witness, Mahadev Shah. And my lord, another thing in the seizure list, your lordship will find column 1, date and hour of seizure. My lord, it's 31st of...
Briefcase belongs to whom?
Briefcase doesn't belong to me. It was there lying in the dicky of the car. If your lordship also believes, my lord...
All are factual aspects.
My lord, Mahadev has been made a witness. Only one more thing, my lord. Kindly see the seizure list, my lord, at page 12. Firstly, my lord, I have the certified copy, which I have, my lord. The photocopy is in your lordship's file. My signature is not there. Firstly. Secondly, my lord, Mahadev is made a witness. Thirdly, my lord, if your lordship sees the seizure when it started and when it completed, 31st of December between 17:25 hours and 20:25 hours. Right, my lord? So, my lord, by 8:25 p.m. in the evening of 31st of December, the seizure had ended. And on the top, my lord, we'll find the reference to the GD entry. Then, my lord, how the original seizure list contains the case number, which is Manikchok PS case number 1 of 2024. The year has changed, dated 1st of January. If the seizure list preparation was completed by the 8:25 p.m., my lord.
Then we have to go to the original GD.
Lordships, my lord. Kindly go through it, my lord. And my signature is also not there.
That can be done in the bail hearing. That can be done at the time of trial.
My lord, but this on the face of it, my lord, indicates, my lord, that there is complete, my lord, manipulation in the seizure list, my lord. And 20 kg, 100 grams, my lord. As if, my lord, as if, my lord, as if, my lord, the weighing scale is of a jeweler. It is so correct.
But it is total
100 grams.
Comes to 27.3
No,
kgs.
my lord, that's not the case.
That
Kindly
is
see
there,
the
my
seizure
lord.
list.
If,
Page
the
14,
seizure
the
list,
chart sheet.
that is not correct, my lord. If it is total, my lord, it is coming to 27.3 kgs.
Where do we get that?
Rejections, or in all the rejection orders, my lord, also it has been mentioned as 27.3 kgs. And my lord, I have calculated.
This is your renewal.
Page, no. First application.
No,
Page 14 is the chart sheet where 27, 100.
My lord, I have calculated each and every seizure,
Lord,
my lord, it is coming to 27.3 kgs.
My signature is not there, my lord, in the seizure list.
Firstly, and secondly, my lord, the first
And it has been
statement,
tampered.
first statement of the petitioner, if you will kindly come to page 14. My lord, there he has exonerated the Mahadev. That is why he had been made an a witness, and his 164 statement is there. If your lordship will kindly come to page 14. That is the 161 of the petition.
Almost 1 year, my lord. 330,
He has
337.
exonerated Mahadev. My lord, stage. My lord,
Charges have not been framed.
Page 14.
Yes, my lord. Of the case diary, my lord. That is the statement of the petitioner. Yes. Because he was coming and they hired the car for, they took a lift, my lord, with a suitcase.
Mahadev washed his hands off. Mahadev washed his hands off.
Whether this statement of the accused can be accepted before police personnel. Why you have not taken 164?
No, 164 is there, my lord, of Mahadev. No, of Mahadev.
This statement has.
My lord, Mahadev, in fact, the vehicle.
Police, nothing, no value in the eye of law.
Well, now charge sheet has been submitted, that is.
Trial has not started. Charge has not been framed.
How many witnesses?
My lord, there are
6 witnesses.
in the
But on
charge 6
26th of
witnesses.
November, supplementary charge sheet has been
But there is
submitted
no
along with the chemical examination report
involvement, my lord.
and 27.3 kgs of gun.
27.
Well,
The learned counsel for the petitioner has submitted that petitioners have been falsely implicated in this case. They are allegedly carrying
Only single petition.
one petition.
One petition.
one petition. Another is absconding.
He was allegedly carrying a commercial quantity of ganja, counting, weighing 20 kg, 100 grams of ganja. Stop. However, charge sheet has been submitted, and there are series of irregularities find in the seizure list. Stop. The driver of the concerned vehicle was shown as witness to the seizure list, though the relevant attaché does not belong to him, it was shown that the petitioner was carrying the contraband articles in the said attaché. However, as the investigation is complete and there is no chance of an early conclusion of trial, he may be enlarged on bail on any condition. The learned counsel has also pointed out that he is in custody for more than 1 year.
No, my lord. 337 days. Almost a year.
11 months. 11
Lord.
Stop. Para. The learned counsel appearing for the state opposes the prayer for bail, stating that there are sufficient incriminating materials against the present petitioner. Stop. The driver was not involved in the commission of the crime, as he allowed the present petitioner to be a passenger along with another co-accused person. However, as there are sufficient incriminating materials against him, his prayer for bail should be rejected. Stop. Para. We have considered the materials on record and all the anomalies as referred to by the learned counsel of the petitioner can be thrashed out at the time of trial. However, there are sufficient incriminating materials showing that contraband articles are recovered from the possession of the present petitioner. We are inclined to reject the prayer for bail. So accordingly, the prayer for bail is rejected. However, the learned trial court is directed to expedite the trial of the case as early as possible.
I'm deeply.
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 No, I beg to adjourn the petitioner.
For the NDPS authority, my lord, already, my lord, the report has earlier occasion served upon my learned friend.
Lord, may I be permitted? There, my lord, if you also kindly see page 14, my lord, there is a direction by your lordship to conclude the trial within a period of 3 months, my lord. It expects
How long you are in custody?
2 years, 1 month, 6 days, my lord. 14 days. My lord, kindly see page 14 once. Page 14 of my petition.
14.
Page 14.
ঠিক আছে.
Second, however, we direct the learned trial court to ensure the trial be concluded within a period of 3 months from the next date. Next date was 5th of July. It completes on 5th of October. After this order, 3 occasion prosecution took time. Out of 7, 5 evidence was examined. 5 cross is fixed on 18 December 2024.
So you have failed to complete.
And my lord,
No, let him complete. I will submit
and
before your
see
lordship. He is
report
not correcting, my submitting, my lord, correctly, my lord.
I have annexed with all of mine.
Very well, I will also submit.
Then I will place the order sheet.
Yes,
My lord, kindly
yes,
see, my lord.
place.
দাদা আমাকে একটু বলতে দিন, আপনি
No,
বলুন।
no, you place.
Kindly page 39, my lord.
39.
Page 38, my lord. Kindly see 9 July 2024 order.
Please fix for
38. 9 July, order number 57. Landed PP files a petition with a prayer for adjournment. Now, my lord, kindly take table to look at page 40. Page 46, my lord. Column 4, it is submitted by the landed PP for the summon upon one of the independent witnesses could not be served due to incorrect insufficient address. Page 40, my lord. Now, my lord, kindly see the next page 41. No, column 4, no witness present. Now, my lord, what happened, my lord?
So out of 8, how many witnesses?
Out of 7, 5 completed, 6 examination in full, part cross examination started. That is the reason I submitted. He is not correcting, submitting correctly. And the next date is fixed for further cross examination of PW6. Already PW6 has been cross examined partly. If your lordship kindly sees my report.
As per your request, we have fixed the time limit for 3 months. Now,
My lord, I will give answer to that. I am duty bound. My lord, kindly see your lordship has been pleased to pass the order on 3rd of July 24. Now 3 months comes on 3rd of October, subject to correction from your lordship. Now kindly see the date of affirmation of this bail application. That is 23rd of September 24. Before 3 months, my learned friend files the bail application. And kindly see the date of affirmation, 23rd September 24. So before 3 months, he files this application as far the affirmation goes, number 1. Number 2, it is not correct that PW5 has been only examined. PW6 has been examined in full, cross-examination part, and the next cross-examination is fixed on 18th of December 24.
Very well. Issue.
And the recovery is 414 of poppy straw from his possession.
From an abandoned place, my lord. Sorry.
No, it is in Borobajar, Malapara. No abandoned place. It's not correct.
The petitioner says, petitioner.
Yes, my lord. Yes, my lord.
That he is in custody for about 2 years, 1 month. Stop. He had approached this court for bail by filing CRM NDPS number 1025 of 2024. Stop. In its order dated July 3, 2024, this bench noted that a co-accused person had approached this court for relaxation of condition of bail which he had been granted earlier. Stop. The application was disposed of by directing the trial court to complete the trial on a day-to-day basis and conclude the same within 6 months from the next date fixed for recording of evidence. Stop. This bench noted that in spite of the aforesaid direction, the trial was far from being concluded. Stop. On the request of the prosecution, this bench had granted 3 months more from the next date fixed for recording of evidence for conclusion of the trial, if necessary by holding the trial on day-to-day basis. Stop. Paragraph. The petitioner says that in spite of all the aforesaid directions, the trial is still pending. Stop. He prays for bail on the touchstone of Article 21 of the Constitution of India. Paragraph. Opposing the prayer, comma, learned advocate for NCB. NCB says that 5 witnesses have been examined fully. Stop. PW6. The examination in chief of PW6 is complete. Stop. Part cross-examination of PW6 is also complete. Stop. In all, the prosecution will examine 7 witnesses.
Fine.
Stop. Therefore, comma, the trial is on the verge of conclusion. Stop. Huge quantity of poppy straw was recovered from the accused persons, including this petitioner. Stop. Therefore, comma, bail should not be granted. Paragraph. The prosecution may have a very strong case against the petitioner. Stop. We say nothing on merits. Stop. However, 2 years, 1 month is far too long a period of time to keep an under trial in incarceration without bringing the trial to its logical conclusion. Stop. Twice time periods were indicated by this court within which the trial was to be concluded. Stop. Such time frame has not been adhered to. Stop. Paragraph. By the order dated July 3, 2024, this bench had clarified that if the trial is not concluded within the time period indicated in that order, the petitioner will be entitled to renew his prayer for bail. Paragraph. In view of the aforesaid, we are inclined to allow the petitioner's prayer for bail. Stop. করে যা condition গুলো দিয়ে দাও।
Shall remain within the jurisdiction of Borobajar PS, excepting for the purpose of attending court.
Where is the trial going on?
City Sessions Court. City Sessions Court. My lord, only
And meet the IC Borobajar PS once in a week.
My lord, only one indulgence I am paying your lordship. Kindly add one line of my submission that this application for bail has been filed before your lordship before 3 months.
Prosecution is here. ওখানে learned advocate further points out that this bail application was filed on
23rd of September.
September 23, 2024, prior to expiry of 3 months
As directed by your lordship.
Granted by the order dated July 3, 2024.
Great.
My lord, I am for the petitioner. In this matter, there was a direction to bring the report. Lordship, our contention is that petitioner herein, from whose custody only 6 kg of ganja was recovered. Lordship, that has been demonstrated as a joint possession. Lordship, kindly come to page 20 of this application. Lordship will find the petitioner's name is appearing in column number 4, where Lordship will find that it is one ash color ladies side. Lordship, this trial has not yet commenced.
Lordship, charge has been framed.
Charge has been
Date
framed
has
and-
been fixed for evidence.
So when he was arrested?
Lordship, he was arrested on 13th of August 2023. Lordship, charge has been framed on 25th of July 2024.
Charge sheet filed when?
Lordship, charge sheet filed.
Lordship, charge sheet was filed.
Charge sheet was filed on. Lordship,
Lordship, 30th November 2023, long back.
30th November 2023.
Why 7 months?
Lordship, after filing of charge sheet, charge has been framed. Thereafter, one application, if my lord, the entire order sheet has been tabulated.
1 year, 4 months, 3 months.
1 year,
1 year, 3 months and some days.
Lordship, the only
3.5 months.
my
it will be.
contention, Lordship, is that they are calculating. Lordship, kindly take the timing also for the recovery and seizure. Timing is completely different.
82 kgs of gaja.
Together it is coming. It's not a case of joint possession, Lordship.
Have you mentioned in this, we called for a status report?
Lordship.
How many witnesses?
How many witnesses you propose to
Lordship,
examine?
that has not been stated in spite of fact that I
Then this-
repeatedly asked him to take instruction from the learned PP and say how many witnesses they want.
Then we take it
That
that
has
we
not
will
been
examine all 16 witnesses. then we'll have to proceed on the basis he will examine all 16.
Yes, when it has not been stated.
And therefore, which may take another 3 years.
Or Lordship may call the IO to explain.
No, why should we?
Why, as per your Lordship, why your Lordship's order has not been complied with?
Doesn't matter. Then the benefit goes to him if you don't comply.
Lordship, kindly record it that is, in spite of your Lordship's order, it has not been reflected in the memo.
Memo of evidence filed in court by the state be kept with the records.
If IO wants something else.
The paragraph. The petitioner says that he is in custody for more than a year.
She, Lordship.
She is in custody for more than 1 year, 3 months. Stop. Witness action has not yet begun. Stop. There are 16 charge sheet named witnesses. Stop. There is no possibility of an early conclusion of trial.
7th and 9th of December, date has been fixed for evidence.
When?
7th and 9th.
Of December.
December.
Stop. There is no possibility of early conclusion of the trial. Stop. She prays for bail on the touchstone of Article 21 of the Constitution of India. Paragraph. Learned State Counsel, while opposing the prayer, says that 82 kg,
330 grams of ganja.
About 82 kgs of ganja was seized from the accused persons, including one sole accused.
Lordship, there are 4 accused. From her, it is 6 kg, which is not
No, 10 kgs.
From the accused persons, including this petitioner. Stop. December 7 and 9, 2024 have been fixed as the dates for examination of witness. Stop. There is sufficient incriminating material against the petitioner. Stop. Bail should not be granted to her. Paragraph. On the last date, i.e. November 27, 2024, we had asked the state to file a status report indicating the stage of the trial. Stop. We specifically directed that the report shall indicate how many witnesses the prosecution intends to examine and the time frame within which the prosecution expects the trial to conclude.
I communicated the order in WhatsApp and talked to the IO.
Learned APP says that he personally communicated this order to the investigating officer by WhatsApp. Stop.
And personally talked to him in phone.
And also personally spoke with him over telephone. However, paragraph. However, in the memo of evidence, there is no indication as to how many witnesses the prosecution intends to examine. Stop. We therefore take it that the prosecution would examine all 16 witnesses, all 16 charge sheet named witnesses. Stop. Hence, there is no possibility of an early conclusion of the trial. Stop. Paragraph. We also note that charge sheet was filed on November 30, 2023. Stop. Charge was framed on July 25, 2024. Stop. In other words, after filing of charge sheet, it took 8 months for the prosecution to frame the charge. Stop. The petitioner is in custody for 1 year, 3 months. Stop. At the pace the proceeding is progressing, it may take years together for the trial to conclude. Paragraph. Hence, without touching the merits of the case, purely on the ground of delay in progress of trial and lengthy custodial detention of the petitioner, we are inclined to petitioner, who is a lady, we are inclined to grateful.
The report submitted by the IO may kindly be kept with the record.
Memo of evidence recorded নিয়ে যখন বলবে grateful.
I'm grateful.
He shall not leave PDPS jurisdiction excepting for the purpose of attending court.
Grateful, my lord.
May I please, Your Lordship?
I'm for this case.
My lord, from 4 persons, my lord, 32 kgs of ganja. From
Sorry?
4 persons, 32 kgs of ganja was recovered, my lord. 2 persons are before Your Lordship. They are in custody.
So 8 kg each.
32 kgs, my lord.
So 8 kg each, 2 persons.
My lord.
Below commercial.
Below commercial. And my lord, they are in custody for 152 days, my lord. Charge sheet not yet submitted, my lord, as a.
Then they don't even press it.
2 persons were
If you want to,
apprehended.
if you, investigation is going on.
My lord,
Yes.
my lord, may I be permitted to withdraw this application?
Yes,
Much grateful.
not pressed.
So for the state,
My lord, I'm for the NCB.
and who is for the petitioner?
My lord, even on the last occasion, the petitioner hadn't turned up, my lord.
The last location also.
Yes, my lord, and my lord was in that situation, my lord.
Which day was that? Which date?
My
was
lord,
that?
last week it was, I believe, on Wednesday or Thursday, my lord. It was on Thursday, my lord.
Order তো হবে থাকবে না কিছু not to don't আসেনি বোধহয় just possible হয়ে গেছিল বা not today হয়ে বাট উনি যখন বলছেন dismiss করে দাও on the last occasion when the matter was called on nobody appeared for the petitioner. Stop. Today also nobody appears. Paragraph dismissed for the petition. ওনারটা নিয়ে নাও এটা appearance-টা নিয়ে নাও. Give your appearance.
My lord. জিজ্ঞেস কর না।
They appear for the petitioner. Charge sheet was submitted without FSL report. Lordship, last order, Lordship recorded. Lordship.
My lord.
And his custody for 220 days. Lordship.
How many months?
Charge sheet was submitted in the month of July 24, 22nd of July. The report was available on 29th of November, and thereafter supplementary charge sheet was filed on 30th of November.
So 180 days was complete
180 days completed on 23rd October. Lordship.
and you filed?
Lord, whether he filed, he exercised that right or not, that is not clear
Filed
from
this
the
application on
petition.
25th September. Lordship.
Then previous.
Because he has not exercised.
Lordship, till 180 days. Lordship. There has been no progress. Lordship. The FSL report was not submitted.
When were you arrested?
Arrested on 27th April 2024. Lordship.
27th April. When would 180 days expire from that date?
On 23rd October 2024. Lordship.
23rd October.
Lordship.
Charge sheet was filed on 22nd July
Lordship.
without FSL report.
Lordship.
Did you exercise your right to of statutory bail before the learned trial court?
Lordship.
When?
Sir,
Lordship, kindly see 11th September order. Lordship. After the affidavit page. Lordship.
11th September still it wasn't 180 days.
No, Lordship. There is not.
Then
But we have filed it, but during pendency of this petition, Lordship, he has covered 180 days. Lord. This is humble submission.
which petition?
This is instant application. Lordship.
Mushkil.
But prior to that, we had not filed. Fact remains, Lordship, before 180 days, Lordship was not filed.
After 180 days, you did not file anything before the trial court.
Lordship. Lordship. But during pendency of this petition, Lordship, this
exercise.
Come back. Similar issue is there's involved in another matter which we have kept for Thursday,
Fine.
not today. You see, the problem is you filed this application before expiry of 180 days.
Lordship.
Can this be treated as an application for statutory bail? That is the question.
Whether the abatement is made or not. They have not made any abatement to that
Lordship.
effect that
No, that word statutory is not
But-
necessary.
My Lord, after filing this application, Lordship, I am covered by Lordship judgment. 180 days was completed.
You are
Lordship.
not, you're missing the point again.
Lordship.
Chalo,
Item 36. 36 is my application, my lord. My lord, the petitioner is in custody for more.
My lord, 3 years, 1 month, trial has not started. What
Trial not started, my lord.
The next date is on 7th and 8th of Jan.
What was recovered? Just as a matter
2 kg codeine.
Of codeine mixture, my lord.
kilos.
My lord,
Who accused?
sole accused,
Sole
my
accused.
lord.
How many witnesses?
6.
6.
Hey, When was charge sheet?
My lord, charge sheet filed in 2022, my lord,
2022.
Can you give us the date? And charge framed?
My lord,
Charge-
this year, my lord, on the
charge framed on 25th of July 2024.
25th July 2024,
And the charge sheet?
30th of March 2022.
Is this the first time?
Yes, ma'am.
The petitioner says that he is in custody for 3 years, 1 month. Stop. Witness action has not yet begun. Stop. There is no possibility of an early conclusion of the trial. Stop. On the touchstone of Article 21 of the Constitution of India, comma, he prays for bail. Paragraph. While opposing the prayer, comma, learned state advocate points out that charge sheet was filed on March 30, 2022. Stop. Charge was framed on July 25, 2024. Stop. Examination of witness has not started. Stop. The next date fixed is
7th of January and 8th of January.
January 7 and
Thrice the schedule has followed.
2025. Paragraph. We see that it took about 2 years, 4 months to frame the charge after filing of charge sheet. Stop. We also see from records that 3 schedules fixed by the trial court for examination of witnesses failed completely. Stop. No witness turned up. Stop. At this rate, there are 6 charge sheet named witnesses. Stop. Trial has not even begun in the sense that witness examination has not started. Stop. Paragraph. One cannot be oblivious of an under trial person's fundamental right to speedy trial and personal liberty. Stop. The petitioner is in judicial custody for more than 3 years, 1 month. Stop. On the ground of solely on the ground of delay in progress of trial and lengthy custodial detention of the petitioner, we feel impelled to allow the petitioner's prayer for bail.
Shall not leave Boranagar police station jurisdiction excepting for the purpose of attending court proceedings, and shall meet the IC Boranagar PS once in a week until further order.
Great 2 months.
My lord, I am for the petition. For
My lord,
NCB.
I am in custody for 1 year, 9 months, 7 days. My lord, till date, out of 10, only 1 witness had been examined. My lord, the complaint was filed on, since it's a Union of India, my lord. So
To
it
file
is
any report, or do you wish to file a report? Yes.
charges, complaint was filed on 25th of August 2023. Charges were framed on 10th of April 2024. And 6 dates, no witnesses turned up. Only 1 witness out of 10 had been examined.
And you are in custody?
1 year, 9 months, 7 days.
My lord, all total 9 witnesses, my lord.
Well, they are responsible for the delay.
My lord, may I, my lord, it's not 6 days. Consecutive dates fixed. My lord, PW1 concluded. PW2 and PW3 have been called for, my lord, OPS call, my lord, urgent training, and my lord, they have been posted in Jammu Kashmir for some emergency call, my lord. So that's why they could not join on, my lord, could not attend on the last 2 dates, which were fixed on, my lord, 4th of November, 5th of November, 6th of November. The date is fixed on 18th of December this month. PW23 summons have been issued, my lord. May I hand up copy of this, my lord?
What are the contraband article?
How are they responsible?
My lord,
How are they or he? Actor.
My lord, 1. My lord, this is the order sheet. No witnesses turned up. My lord, this is the order sheet.
recovered from
Recent
their
order sheet.
possession only. May I?
What was recovered?
1225 bottles of NCB.
1225 bottles of NCB recovered from the
My lord, this is the order sheet. Recent order sheet. 6 dates, no witnesses
18th of
turned up.
December, this month, my lord. This month it has been fixed.
So you can appear now virtually.
Yes.
There is no problem.
But it's in the border area, my lord, probably, my lord.
Physical appearance is not required right now.
I completely about it, my lord. They are in Indo-Pak border, my lord. Probably the connectivity and other issues may cropped up. I do not know.
The problem is you may have a very good case, but the problem is only Article 21 and the Supreme Court decisions. Therefore, our hands are bound.
Yes. My lord,
There's no possibility of an early conclusion. 1 year, 9 months already in custody.
No, my lord, they have been summoned. They will appear on 18th of December, my lord.
That we don't know.
My lord,
Even assuming they do,
Lordship.
still another 7, 8 witnesses will remain.
6 witnesses will remain.
To be examined.
All total 9. My lord, 3 will be concluded and the 4. My lord.
Had you made a statement before us, or if your report said that in 3 months we'll conclude, we could have recorded that. But I'm sure there's nothing of that kind in your report.
No, my lord, that, my lord, is not there. But since he's the only accused person, my lord, and the possession has been recovered.
Sole accused.
Sole accused.
Sole accused.
Two. Another one is absconding as well instructed.
Sorry, sir. Sorry.
Lordship, the 18th of December, Lordship, kindly appreciate this part. It's
No, 18th of December, the trial is not concluding.
Lordship, my lord.
Then
my lord may kindly, my lord, pass a direction to conclude the trial.
We cannot. Again, because of Supreme Court's decisions. We cannot. Renewal.
No, my first time.
The petitioner says that he is in custody for 1 year, more than 1 year, 9 months. Stop. Only 1 out of 10 charge sheet named.
9, my lord, 1 of 9.
Charge sheet named 9.
9.
My lord, to my
Total number of witnesses, my lord, Lordship, kindly sees the, my lord, report, my lord.
To my instruction, it was 10.
9 charge sheet named witnesses has been examined. Stop. On the last 6 dates, fixed, no witness turned up. Stop. At this rate, nobody knows when the trial will conclude. Stop. On the basis of Article 21 of the Constitution of India, he prays for bail. Paragraph. The Narcotics Control Bureau files a report. Stop. Let the same be kept with the records. Paragraph. Learned advocate for NCB, bracket NCB says that December 18, 2024, has been fixed as the next date for examination of PW2 and PW3. Stop. They are both police personnel. Stop. They were summoned for urgent training and posting on the border area.
BSF.
Stop. Stop. All efforts will be made to conclude the trial at on an early date. Stop. 1225, 1229 bottles.
1225.
1225 bottles of penicillin syrup containing codeine phosphate was recovered from the exclusive possession of this petitioner. Paragraph. The prosecution may have an iron cast case against the accused person. Stop. We say nothing on merits. However, that cannot justify custodial detention of the accused person for an indefinitely long period of time. Stop. 1 year, 9 months is a substantial period of time. Stop. The trial has not progressed to any appreciable extent. Stop. It is anybody's guess when the trial will conclude. Paragraph. Hence, without touching the merits of the case, solely on the ground of delay in progress of trial and prolonged incarceration of the petitioner, we feel constrained to enlarge the petitioner on bail.
One thing, why you have raised this connectivity issue? The trial is going on in Barasat. So there is no connectivity issue. Whatever it may be, he shall not leave Barasat PS jurisdiction and shall meet the IC Barasat PS once in a week until further order. Use that virtual mode. Clearance virtual mode.
My Lordship, My Lordship, I am here for the petitioner. My Lordship, I am here for the petitioner. I am seeking the bail on the delay in trial as well as on parity. One of the co-accused has been granted bail, My Lordship.
My lord, only difficulty is he is a resident of Bihar. He was apprehended from Gazul. My lord, yes. Only keeps him in the within the
Calcutta is a very good place.
within the
Okay.
municipal limits of
If we
Kolkata.
at all allow his prayer for bail.
Although your lordship had observed only Article 21.
Co-accused has been granted the bail also, My Lordship. That is there.
I must tell your lordship that the defense had in fact been cross-examining the PW2 for last 5 days and still cross-examining. But since your lordship had already observed,
The petitioner claims parity, citing an order dated November 13, 2024, passed in CRM NDPS 1549 of 2024, whereby a coordinate bench enlarged on bail a co-accused person, namely Mohammad Ismail Sheikh. Stop. The petitioner says that he stands on the same footing as that person insofar as delay in progress of trial is concerned. Paragraph, learned state advocate, while opposing the prayer, in his usual fairness, does not dispute that this petitioner is similarly circumstanced as Mohammad Ismail Sheikh insofar as delay in progress of trial and lengthy detention, custodial detention of the petitioner is concerned. Stop. Paragraph, hence, on the ground of parity, we allow this application. Grounds are same grounds for you.
same, my lord, only additions, my lord, not to leave the municipal limits of Kolkata and to meet the officer in charge, STF.
Shall remain within the jurisdiction of
Municipal limits of Kolkata and my lord shall not shall meet the officer in charge of the STF once in a
STF. In the STF, once in the every week.
Special task force. STF
special task force. This was interstate, so STF.
Oblige, my lordship. Oblige.
Yes.
Again, from the petitioner, my lord, the allegation of cultivation of cannabis, dag number 3131 and dag number 3106, my lord. And my lord, the only for my lord, the petitioner is not a owner of that land, my lord. My lord, Kornodhar Badik is the owner. Kornodhar Badik is the owner of the my lord 1 shotok land, my lord 3131 and 6 shotok land, and my lord 3106, my lord.
Your father,
my lord. But there is a seven, my lord, seven son and daughter. And my lord, the division on 1 shotok, my lord.
Family business.
No, my lord. No. He's a barber, my lord, not cultivator, my lord. My lord, only for my lord recovery of
one witness action started.
my lord, 1 minute.
How long in
my lord,
custody?
241 days, my lord. My lord, kindly page number 12, my lord, kindly see the only for my lord the involvement recovery of green color cannabis plant,
sir.
330 gram, my lord.
If you show
below
us,
commercial
if
quantity.
you show us,
That is the one plant has been weighed. Entire area has been.
if you show us further material, we'll reject on merits. We are giving you a choice now.
My lord.
Whether you shall withdraw or we shall proceed.
We
Not
don't have
question.
much time.
Not question.
Cannabis এর চাষ করছে। বলছে দেখেছো দেখেছো ওয়ান কর্ণধার বাড়ি ও নিজের বাবা।
my lord, in this my lord, in this matter, my lord, on the last occasion, my lord, I have raised the point of Idul Mia, but my lord, he has pointed out that before filing of this bail application, the FSL report was sent to the learned court below. Only that much, not charge sheet. So,
Directly.
no, directly it has been sent. My lord, this is the point. So, my lord,
what is the prejudice it was to you?
my lord, because
Prejudice
my lord,
you have suffered.
my lord, kindly take 2R of the CRPC. What is police report? Your Lordship is having but 2R. Police report means a report forwarded by a police officer to a magistrate under subsection 2 of section 173.
173.
এই মাইলর বই চাই
একটা CRPC
তিনটে বই নিয়ে আসবি কঠিন হিয়ারিং করতে গেলে জজ সাহেবের জন্য দুটো বই আনতে হবে
আর একটা CRPC
173. Yes. Yes, definition part. What?
মানে 2R police report. খুলে দাও Police report means a report forwarded by a police officer to the magistrate under subsection 2 of 173T. মানে 173(2) says, as soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered. দিয়ে দাও একটু দিয়ে দাও না অসুবিধা হচ্ছে তাহলে মানে I beg apology. 173 deals with that particular report.
So we have directed to submit FSL or something like that.
No.
He 170
He has not
173 2 I says, as soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report or report in the form prescribed by the state government, stating A, name of the parties, nature of information, name of the persons, and D, this is the most important one, whether any offence appears to have been committed, and if so, by whom. So, this police report has to be forwarded by the officer in charge. Now, this will be called as a charge sheet. My lord, unless and until this is being forwarded by OC in form of police report, magistrate cannot take cognizance. Kindly take 191B now. 190 subsection 1 clause B. Cognizance of offences by magistrates. Subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class, specially empowered in this behalf under subsection 2, may take cognizance of any offence. A, upon receiving a complaint of facts, mala this is a complaint case, in that case. B, upon a police report of such facts. This is the police report. This is under section 173(2). Mala the fact of this case is that it's true that it has been sent down to the learned court below, but it has not been forwarded by OC by way of a charge sheet unless and until this is ready for cognizance.
What is the contents of that? The positive or
positive? It's positive. But the thing is that when magistrate has only seen he's exercising his monitoring power under section 156 clause 3, not under 190, unless and until.
What prejudice it was to you? I want to know.
My liberty will be curtailed.
I shall pass water.
My liberty will be curtailed. This is one
submitting for the liberty, my lord, what I gather, but whether he has filed this petition within that expiry of 180 days.
Yes.
After expiry of 180 days.
Yes. Malad, I am giving your lordship the date. Malad, the first charge sheet was filed on 16th August 2024. No 36A subsection 4 has been filed by the public prosecutor for extension. This 180 days expires on 19th August 2024. My lord, the
19th August.
19th August 2024.
And charge sheet filed?
Before that, 16th August.
16th.
My lord, this FSL was sent to the landed court below on 26th September 2024. 27th, I filed this bail application before your lordship, stating that I am paying for statutory bail, that is at paragraph number 7. And supplementary charge sheet has been filed on 30th October. Unless and until this supplementary charge sheet comes into play, my lord, cognizance cannot be taken. This supplementary charge sheet ought to have been filed before my filing of this bail application. That is precisely my
that FSL was sent
to the
and seen by the learned trial court on 26th of September.
Yes.
My lord, kindly see.
Sir, just sending may not be enough. It has to be a part of the charge sheet.
My lord, that has been filed. If he is
But before that, he has exercised his right.
But my lord, he has not prayed the has not filed this application before the learned trial court.
Doesn't matter. He
My
can
lord,
file before us.
Yes, my lord. But before that, the charge, the FSL was seen by the learned trial court on
What is
26th of.
seen? Is that seen enough, sir? If he seizes it and keeps it in the drawer forever, in the desk, you will not have to make it a part of the charge sheet. That is exactly on that basis we have decided Idul Miya and Rakesh Shah that without the charge sheet, without the FSL report, it is no charge sheet at all. That's the simple point. You want to look it up, you want to look the law,
Yes,
do some research, come back. Whether just sending it by the director of FSL to the learned trial court is sufficient. Show us, then we'll
in Rakesh Shah, paragraph 11, my lord, I am pointing towards.
Yes, we remember.
And my lord, in Tularam, paragraph 8 and 10.
Yeah, this is a different issue here. The concerned office sent the report directly to the court,
but
and on after receiving that report by the court, you filed. Different issue.
My lord, this has to be forwarded with the supplementary charge sheet. My lord, I would have no case if the supplementary charge sheet was filed on 26th, because I filed this on 27th. My right goes away.
We shall consider, and you come back with your instruction sometime.
1 week.
1 week.
1 week.
Heard learned counsel for the parties. The material facts, paragraph appear to be that charge sheet was filed on August 16, 2024, but without the FSL report.
Yes, ma'am. And no extension was paid. And no application.
No extension of time was paid for by the investigating authority under section 36 capital A, bracket 4 of the NDPS Act. Stop. On 9th August, paragraph, on August 19, 2024, 180 days expired from the date of arrest of the petitioner. Stop. Paragraph. On September 26, 2024, the FSL report was sent directly by the laboratory to the learned trial court. Stop. On September 27, 2024, the present application was filed by the petitioner praying for statutory bail. Stop. Paragraph.
On 30th October?
On October 30, 2024, the supplementary charge sheet was filed along with the FSL report. Paragraph. The short question of law that arises is whether by receiving the FSL report directly, whether by the FSL report, whether by the FSL report being sent directly by the laboratory to the learned trial court, the same became a part of the charge sheet or not. Stop. Whether or not, stop. Whether or not, after receipt of the FSL report by the learned trial court, but before filing of supplementary charge sheet, comma, the petitioner could have exercised his right to avail of statutory bail. Paragraph, learned advocate seeks some time to come back better prepared on this issue. Paragraph lists this matter once again on next week, Tuesday. Next week, right, the others. Interesting. Do some homework.
Deep apply.
Eh?
Lord, I'm filing supplementary affidavit annexing
matter,
the
my lord.
Interim bail,
Yes,
interim.
my lord, that matter.
My lord, I am
Other
filing
side.
also original death certificate.
He has annexed the death certificate in the supplementary affidavit.
Page number 4, my lord. Page number 4, my lord.
Yashul, Devajyoti.
My lord, according to his prayer, my lord, all rituals will be over by 6th of January.
6th of January.
The petitioner says one petitioner or two?
Two petitioners, my
The
lord.
petitioners say they are brothers,
Yes, my lord.
that their father, Salam Sheikh, passed away on November 24, 2024. Stop. Xerox copy of the death certificate issued by the Department of Health and Family Welfare, Government of West Bengal, has been annexed to the supplementary affidavit which has been filed in court today. Paragraph: the petitioners pray for interim bail to do the last rites of their deceased father. So they say that the entire process would be completed
On 6th of January
would
2020.
be completed on January 6, 2024. Stop. Paragraph: on humanitarian grounds, we grant interim bail to the petitioners till January 8, 2025. Paragraph: accordingly, the petitioners be released on interim
On
bail.
9th January, he shall surrender before the
Yes, my
trial
lord.
court
Yes, my lord.
and he shall be taken into custody.
Paragraph: let's just condition দেওয়ার পরে লেখো this order of interim bail shall continue till January 8, 2025. Stop. By January 9, 2025, the petitioners shall surrender before the learned trial court and they shall be taken into judicial custody. Paragraph lists this matter once again on 10th, January 10.
Or NDPS document.
যেদিন হবে January 10 এসে যাক।
Shall not leave Mograhat PS jurisdiction. এটা লিখতে হবে। হ্যাঁ,
Extremely grateful, my lord.
মিট ফিট করতে হবে না, কাউকে কিছু করতে হবে না।
Grateful, my lord.
It's on 10th or
10th.
thereafter?
10th.
41.
My point is also similar. The statutory bail hearing is to be conducted tomorrow before the learned trial court, because in this matter, chemical examination report has not yet been filed, though the charge sheet has been filed by the authority. My lord, kindly fix it on the next.
On two courts bail application.
No, it was filed earlier. It was filed.
Thursday.
I beg to appear with the petition, my lord. My lord, 34 2 bottles of codeine recovered, my lord. I am in custody for a period of 2 years, 6 months, 15 days, my lord. out of 13, 3 witness examined. My lord, after framing of charge, 8 times prosecution took time. Before framing of charge, 7 times prosecution took time.
No, out of 33 witnesses,
Out of 13, 3 witness examined.
3 out of 13.
And page 22 onwards after framing of charge order.
All the orders
Wish to
have
file a status report.
My lord,
Hey, the petitioner renews or first prayer.
No, renews, my lord. Earlier rejected on 24th of July 2023, page 34.
Renews his prayer.
my lord,
for
only,
bail.
I can submit only one thing, my lord. He has annexed the orders, my lord. From the orders, it appears that charge has been framed on 11th October 2023. And subsequent to that, my lord, 3 witnesses has already been examined. And there is also the court was lying vacant, my lord. That is also evident in the order sheet, my lord. That
File a status report.
and my lord also kindly peruse the
2 years, 6 months.
my
Sir,
lord,
I have
kindly
annexed
see
orders.
this only once, my lord.
Sir, he is responsible for the delay.
My lord, kindly see once this.
Why, Mr. Banerjee? Let us
My
proceed.
lord,
Let
I'll
us
be-
proceed. We renews prayer for bail, which was rejected on July 24, 2023. Stop. He says that he is in custody for 2 years, 6 months, 15 days. Stop. Only 3 out of 13 charge sheet named witnesses have been examined. Stop. Before framing of charge, the prosecution took time on 7 occasions. Stop.
7 occasions and after 8
Framing of
times.
charge, the prosecution took adjournment on 8 occasions. Stop. He prays for bail on the ground of delay in progress of trial. Paragraph, let the state file a status report on the next date. Stop. The report shall indicate, inter alia, how many more witnesses the prosecution intends to examine and the time frame within which the state expects the trial to conclude. Paragraph, copies of depositions of the witnesses already examined should be produced before us on the next date to enable us to assess how far those witnesses implicate this petition. When? Thursday or next Tuesday?
Next Tuesday.
Tuesday week. Dates are the
Well, then reason for delay, my lord.
Hmm?
Report. Reason for delay also.
Status report, yes, of course. What is the status report on the next date, explaining the delay, if it can. Explaining the delay, if it can. Therefore, the report shall also.
Madam, for this.
Lordship, here I am relying upon your Lordship's order of Idul Mian. Now, Lordship, petitioner was arrested.
All recorded, Mr. Chatterjee, 3rd December.
Now, Lordship, in the meantime, I obtained fresh certified copy. Lordship, supplementary charge sheet was submitted on 19th, এইটা একটু দিন না একটা অরিজিনাল একটা জেরক্স Now, 19th of September 2024, supplementary charge sheet was submitted. Now, my bail prayer was filed on 6th of June, which was rejected on 11th of September. So, after my rejection, this supplementary charge sheet was submitted.
We have understood. FSL report?
My
Not
lord,
yet
the
filed.
report, FSL report submitted before the learned court on 8th September 2024. And my lord, this bail application filed on 30th September 2024.
Irrelevant, sir.
My lord,
irrelevant.
My lord, his submission, there is nothing mentioned in the averment what he is submitting before your lordship. He is, my lord, claiming parity of that particular order, but that is not mentioned in the averment of this petition. My lord, only on the basis of verbal submission, that will not
I
suffice.
have
my lord.
annexed entire order sheet.
My lord,
I
that
have
order has-
order dated 6th of June 2024. That you also will find.
And my lord, the order
3rd of June, charge sheet submitted without chemical report. 6th of June, I made an application, specifically statutory bail, that was finally disposed of on lordship 11th of September. On 6th of June, it was not disposed of.
Correct. It appears from record Whatever when do you need?
My lord, that is not mentioned in this bail application. And my lord, kindly see the order dated 11th September. My lord, there
Have
this
you-
prayer was not made. There this prayer was not made before the learned court below.
See the order dated 6th of June.
My lord,
See the order. You will read only half the papers. See the order. After reading this order, you will say prayer was not made.
My lord,
See what the order is. What did the defense counsel argue?
my lord, I am just, my lord, placing that the bail application which has been filed before this court, I am only arguing on that basis, my lord.
He
My lord, I have seen.
He exercised his statutory right.
My lord, my lord.
Issue. Read order dated November 27, 2024. Paragraph. 180 days expired from the date of the petitioner's arrest on June 3, 2024. Stop. In the meantime, although charge sheet was filed within 180 days, it was so filed without the FSL report. So, the petitioners, applied for statutory bail before the learned trial court on June 6, 2024. So, their application was finally rejected on September 11, 2024. Stop. The FSL report was filed along with supplementary charge sheet on
19th of September 2024.
September 19, 2024. Stop. The present bail petition was filed on September 30, 2024. But then this statement is not correct in the earlier order. FSL report is still not a part of the charge sheet.
Because that is why I bring fresh certified copy and with the entire order sheet.
Ajay. Paragraph. We therefore see that upon expiry of 180 days, the petitioners exercised their right to statutory bail since the charge sheet was not accompanied by the FSL report. Stop. Subsequent filing of the FSL report will not adversely affect such right of the petitioners as petitioners. Stop. This would follow from the division bench decision in the case of Idul Mia in CRM such and such. Stop. Paragraph. In view of the aforesaid, we are constrained to allow the bail prayer of the petitioners.
Grateful.
Deeply.
Forty-four, my lord, I beg to appear under the petition. My lord, I am appearing virtually, my lord.
Why?
My lord, there is Sat ceremony in my house today.
Oh.
My lord, with regard to the co-accused person, my lord had passed an order recently on 27th. My lord will kindly see the order. My lord will kindly fix it on 5th of December along with the other application of the co-accused. Well, 6 out of 8 witnesses have been examined. The IO has not been examined because he is undergoing treatment in Bangalore, my lord. He is not being able to present himself before the learned court below. So, my lord had called for a report.
Yes.
So, that report, my lord, with regard to the co-accused, that is fixed on 5th. My lord, I will gather the report on 5th for this accused as well.
We'll keep it on the 5th.
My lord, on 5th.
Learned advocate for the state says that the bail petition of a co-accused person has been directed to be listed on December
5th,
2024. Stop. Let this matter be also listed on December 5, 2024, immediately after CRM NDPS 1588 of 2024.
Yes.
Where's your Kaushik? পরের দিয়ে দেবে।
Grateful.
নিয়ে নিয়েছো এটা?
Then 45.
Lordship, item 40.
Not a nice ringtone. Should be changed.
Lordship, I am for the petitioner. The petitioner is in custody for about 465 days. That is 1 year, 3 months, and 7 days. There are total 13 charge-sheeted witnesses, but out of 13, only 1 has been examined till date.
How long you in the custody?
1 year.
465 days, Your Lordship. That is 1 year, 3 months, and
65 kg exclusive possession.
65 kg of ganja from this petitioner.
He is from Orissa.
She is from
Orissa.
Orissa. Told you.
1 year, 3 months.
And 1 out of 13.
13 will be within 6 months we will complete. That I have taken instruction, brother.
Shall we record that?
Yes, yes, brother. That's
record.
How is it is being carried? How it is being carried? In that
yes, set. Train. Yes.
Boys,
no.
first time you are moving.
Yes, Your Lordship.
But first time is moving, my lord. That's why, my lord, I should be very candid. My lord, the supplementary charge sheet was filed after the statutory period. That he is not arguing, my lord. But it should.
Right.
Yes. That consideration, my lord, I can.
Oh.
But she is from Orissa, my lord, within the Howrah limits.
That's all right. Give me the dates. Date of your arrest.
I was arrested on 25th August 2023. The charge sheet was filed on 16th February 2024. The charges were framed on 25th
Charge frame not necessary. 16th February 24, charge sheet filed.
Yes, Your Lordship.
But without FSL.
Without it.
Without it.
And then when did you apply for bail before the learned trial court?
4th of
4th of
September.
And 16th it was filed the supplementary.
I
So
see.
that's why, that
Very good gesture on your part.
Extremely.
Being the
extremely.
officer. Being of the
You
officer.
should be grateful to him.
No, no, no.
Your senior.
He should be grateful to your lordship because after all your lordship's order, then only she will be benefited. Otherwise,
Last time he is moving here.
yes, that's why, my lord, I
First,
Yes, sir.
the first
Yes, Your
appearance
Lordship.
in the
First
profession.
appearance. Yes, Your Lordship.
4th September is the rejection order also.
yes, my lord, that's here then.
Very well. And you filed on the
On my lord 16th.
16th. Esho.
But you have to
But she is
decide
from Orissa, my lord. She has to stay in.
Howrah.
Yes.
You have to decide in Howrah jurisdiction. Okay. On that
Okay,
condition, we can grant it.
Okay,
Because
Lordship.
evidence is going on, my lord.
The petitioner prays for statutory bail. Stop. She says that she was arrested on August 25, 2023. Stop. The charge sheet was filed on February 16, 2024, but without the FSL report. Stop. On September 4, 2024, she applied for statutory bail before the learned trial court. Stop. The learned court rejected the prayer. Hence, this application was filed on September 30, 2024. Paragraph. While opposing the prayer for bail, learned state advocate says that the FSL report has been filed by way of a supplementary charge sheet on September 16. 2024, stop. However, in his usual fairness, he admits that prior thereto, the petitioner exercised her right to obtain statutory bail. Stop. Therefore, subsequent filing of the FSL report with the supplementary charge sheet would not defeat such right of the petitioner. So, we appreciate the fair stand of the learned state advocate. Stop. He is absolutely right. Stop. Once an accused person exercises his right, his oblique her karo, to obtain statutory bail by filing an application prior to complete or lawful charge sheet being filed, an indefeasible right accrues in favor of that person. Subsequent filing of complete or lawful charge sheet cannot take away such right. Paragraph following the ratio in the case of our Idul Miya, we are constrained to allow the petitioner's prayer for bail.
He shall remain within the jurisdiction of Howrah PS and
Yes,
shall not
Lord.
leave.
Yes, Lord.
Thank him.
Grateful to your lordship, deeply.
I'm for the petitioner, my lord. My lord, petitioner is in custody for 10 months, 7.175 kgs of silver and 91 bottles of fentanyl recovered from him.
Silver. Oh,
Yes, Manoj.
This silver.
silver comes under NDPS.
No, that for that they have a separate IPC sections are also there. Manoj, 413, 414, 379
Habitual
IPC.
offender.
Habitual offender.
411, 413.
413, 414, Manoj.
Habitual
Those are
dealing-
there.
Dealing with stolen property. Yes. Yes. Tell me. How long you are in custody?
My lord, 10 months.
10
Cha-
months.
Yeah, charge framed on 18th of September 2024. 13th of December and 16th of December fixed for evidence.
10 witnesses are there.
No witnesses.
10 10.
Yes, Manoj.
There.
The charge has been framed on the 18/9/2024, and thereafter, Manoj.
We are not going to allow your prayer, whether you withdraw or.
And I have to take instruction from my senior. I have to take instruction from my senior, my lord.
Planet Counsel for the petitioner has submitted that petitioner is in the custody for about 10 months. The investigation is complete. And as such, he may be enlarged on bail on any condition. Stop. Parrot. The Learned Counsel for the state opposes the prayer for bail. Stop. According to her, the charge was framed on
My lord, 18th of September 2024.
18th of September, and the first schedule was fixed on
My lord, 13th of December and 16th of December 2024.
and as such, the petitioner cannot take the plea of causing delay from the side of the prosecution. So, according to her, how many witnesses are there?
My lord, 10. 10 charge sheeted witness.
There are 10 charge sheet named witnesses, and the investigation shall be trial shall be concluded within a very short span of time. Stop. In view of the materials on record, including the serial list, and also the fact there is no plea of causing delay from the side of the prosecution, we find that the petitioner has not been able to override the provisions mentioned in section 37 of the NDPS Act.
Restrictions.
The restriction notice. What write the restriction of the we are not inclined to allow the prayer for bail of the petitioner at this stage. However, considering the period of detention, we request the learned trial court to expedite the trial of the prosecution, trial of the case as expeditiously as it can.
Grateful, Your Lordship.
Preparation for the workshop.
When we allow your prayer for bail, you smile. When we reject, you should also smile. Yeah.
Item 47.
47, I am for the petition, Your Lordship. This is renewal.
I'm okay.
This is renewal of prayer of bail application. Well, a charge framed on 3rd of May 2024. There are 9 witnesses. Not a single one has been examined till date, my lord.
Proceed, kindly seize the earlier rejection order
You are in custody for?
Custody for my lord,
from
254
22nd of
days.
February. From 22nd of February.
The case of the year 24 of the year 24.
Lordship. Proceed, he has been arrested on 22nd of February 2024. His prayer was turned down on 25th of June 2024. Thereafter, supplementary charge sheet was filed on Lordship, just before 5 days. Supplementary charge sheet was filed on 21st of June 24. Now, Lordship, copy charge has been framed on 29th of July 24. And next date has been fixed on 11th and 12th of December for evidence. Only 10 witnesses are there.
Same. There is no delay on the part of the prosecution. So you shall allow.
Only 10 witnesses.
That means rejection of your bail prayer. Not pressed or we shall proceed. Asun. The learned counsel. We are going to reject your prayer as there is no delay.
We give you a choice. Consult your senior brother there sitting, ask him.
Not press, my lord.
Yes. Senior.
No, my lord.
Why? Junior fraternity.
No.
Lordship, policy.
My lord, on behalf of the petitioner, I am not pressing this application.
That is excellent news.
It is a loss. I'm in custody for 270 days. Out of 15 witnesses, my lord, 1 has been examined. Next date has been fixed on 10th of December.
What was seized?
58 kgs of ganja from 4 persons.
March.
Now the seizure list.
Case was started on March 2020.
Yes, my lord.
So very.
Now the seizure list, my lord, does not describe what was recovered from whose possession.
Joint possession.
Joint possession certainly, but now on many bags were there. Now they have.
We cannot say that there is a delay.
No, I am not taking up that point.
No.
What point?
I'll keep on doing. Not inclined, sir. Not inclined.
But would it be your lordship pleasure to direct, preferably within 6 months?
No.
Preferably.
No time period. We can general expedition, we can say.
Not
So item number 50 on behalf of Mr. Milan Mukherjee, I am paying for only not today.
Why? Why is
Mr. Mukherjee, due to some personal difficulty, left that.
38?
Chalo.
51.
My lord, wait, I'm 51.
Can you repeat?
Yes. 51, 52, same matter.
51, Mr. Gaurang, for NCB.
Where's the petitioner?
My lord, I'm for the
52, I'm
petitioner, my lord.
opposing for NCB.
I'm praying for not today, my lord. 51, 52, my lord. My lord.
Raja,
No,
My lord,
MDA.
it's not MDMA, my lord. MDMA.
More.
Not
MDMA.
Different, my lord, MD.
It's methinyl,
Coming from Nigeria.
Drug.
methylene, oxybutyramine,
Contraband substance.
hydrochloride. Its
Where is
commercial
an
quantity is 10 gram above. And here it is more than
1 kg is
1.6
670.
1.6 kg.
1.6 kg.
not today.
Much grateful.
The international racket.
I'm praying for not today, my lord.
On behalf of the petitioner?
Stay.
On
Stay.
behalf of
We are
state.
the petition.
Item 54.
My lord, item number 54, I'm on behalf of the petitioner, my lord. I'm seeking for the petitioner's accommodation. Gratefully, lord.
Item 55.
May I please, your lordship, my lord? I'm for the petitioner, my lord. My lord, this is the case, my lord. My lord, the petitioner was arrested, my lord. He's in custody for more than 130 days, my lord, almost 130 days. My lord, he was arraigned in this case, my lord, on the basis of the co-accused statement, my lord. Nothing has been recovered from the petitioner, my lord. My lord, no, my lord. My lord, I have annexed the order sheet, my lord. One of the charge-sheeted accused person, my lord, Amit Shonnokar, has been granted bail by this honorable court, my lord. Page 9, my lord. Same footing, my lord, as per my knowledge, my lord.
Sir, are you aware that your bail prayer was rejected on, anticipatory bail?
Anticipatory bail.
Anticipatory bail was rejected.
Rejected.
Yes,
huh?
sir. Anticipatory bail. Thereafter I was arrested, my lord. Taken into custody.
All detailed records.
Yes.
My lord, if your lordship kindly goes through the order sheet of the last accused person who was granted bail by this honorable court, my lord. There also, my lord, CDR was, it was alleged that CDR matched, my lord.
Page number?
My lord, page number 9, P1, annexed to P1, my lord.
Yes.
Amit Shonnokar, my lord. My lord, on the fourth paragraph, my lord.
Only phone call.
No, my lord, I will be stating, it is my duty to state everything. Some may go against me. Now, my lord, he is relying upon this page 9, wherein my lord would kindly come to page 10. While this was in other cases, two of whom relates to narcotics, no narcotic was recovered from the petitioner. Now, my lord, so far as this petitioner is concerned, there is an NDPS case, there was direct recovery. However, my lord, he has been acquitted from that case in spite of direct recovery due to non-compliance of 40, 52 and 57 NDPS.
Criminal antecedents.
Apart from that also, there are two other cases, although not NDPS, but 406, 379, 392 is there. Now, in this case, my lord, what is against him? Apparently, he was supposed to be the receiver of the properties. The persons with the contraband got arrested. There are telephonic communications and there are statements of the locals, my lord would kindly see, where from it clearly appears that he is predominantly dealing with narcotics. My lord would kindly see these two statements. This was considered by the coordinate bench while rejecting his prayer for pre-arrest bail.
130 days.
My lord, one more thing, my lord, if I...
Charge
My lord,
sheet
as per my... Yes, my lord.
Yes.
Charge sheet filed, my lord.
Yes.
On April 24, my lord. My lord, as per my learned friend's contention, my lord, the petitioner, one of the accused person, my lord, charge sheet person, Nitai Singh, he has been granted anticipatory bail by this honorable court, my lord. I have forgotten to annex this, my lord. My lord, as per the allegation, my lord, he purchased the narcotics, my lord. He purchased the narcotics. He was supposed to deliver it to my client.
Your acquittal in the earlier case was on technical grounds.
Yes.
No, my lord, in terms of this case,
was
my
not
lord.
honorable acquittal.
My lord, I'm not on that, my lord. I'm just on...
I'm on that. Antecedent. No,
Yes,
not inclined. What do
Antecedent.
you want to do? We are not inclined.
This is the judgment also on technical grounds.
My lord?
We are not inclined.
As per your lordship's discussion, my lord.
No, what shall we dictate an order or what?
Withdraw, you can withdraw.
Well, I'll not press this application. my lord.
That's the choice we were giving.
Much grateful, my
But
lord.
it was my duty to point out that he has been acquitted. Yes. No, this. I'm grateful.
I'm praying for not today, my lord. Let's say I'm praying for not today.
No, 56, not today.
57.
No, 57 is the case, my lord. 57. 57 also not today. But he is otherwise, otherwise not raised. Not today, not today.
Not today.
Not today. Not today. He is entitled to bail due to a non-submission of FSL report along with charge sheet.
Not acquainted with the fact.
Not.
Lord, 58 similar prayer, my lord. Not
My lord, not today. State.
80 not.
My lord, I am for the petitioner.
I'm praying for not today, my lord.
My lord, I am for the petitioner.
I'm for the state.
হবি তো?
হ্যাঁ, ওগুলো তো আমার ছিল।
My lord, Idul Mia. My lord, the petitioner was arrested on 1st of January 2024. My lord, with 100 bottles of Fencidril. Charge sheet was submitted on 24th of May 2024. My lord, my lord, charge sheet without chemical report was submitted on 24th of May 2024. Till 11th of September 2024, there was no FSL report. My prayer for bail was rejected by the learned jurisdictional court on 11th of September 2024. Till that time, there was no FSL report.
As of date, is the FSL there? No.
No, my lord, 16th.
Till now, not there.
No, my lord, 16th of December is fixed for framing of charge.
It should what can be done? Idul Mia.
My lord, will kindly see page 55. The chemical
How-
examination report is there.
Has it been filed by way of supplementary charge sheet? Where page?
55, my lord. No, my lord, not the charge, supplementary charge sheet, my lord, but this report
What is the date of the FSL report?
This is the chemical examination report dated 6/9/24.
My lord, will kindly comes to the order dated of the jurisdictional court that I have annexed, 11th of September 2024. My lord, that is the last 11th of September 2024. My lord, the last line to date 30th of September 2024 for production and chemical report. That is, my lord.
Chemical report is there, my lord.
My lord, the order dated 11th of September 2024. My lord, the last line your lordship will see is to date 30th of September 2024 production and chemical report. So, my lord, till 11th of September 2024, there was no FSL on record.
3/7/2024, State Drugs Control and Research Laboratory has submitted report. Okay.
My lord, I am submitting from the order sheets.
Take instruction.
My lord, I am submitting.
Maybe you are submitting, but
My lord, supplementary charge sheet has been filed, my lord, dated 22/9/2024.
So, my lord, after I filed this bail application.
then, and this FSL report was filed with the supplementary charge sheet.
Yes, my lord.
Yes.
Are you sure? Because
My lord, chemical report is there. My lord, thereafter, along with supplementary charge sheet, the other report which was supposed to come, my lord, that is not with me right now. I only have till the charge sheet, my lord. And this is a part of the charge sheet, not the supplementary charge sheet.
which is a part of the charge sheet?
But my lord, will kindly give it back to
The
me.
FSL report.
My lord, this one.
Yeah.
The one that I took out, my lord, the chemical analysis report. But I'll take specific instruction and come back.
Very simple. The charge sheet that was filed on 24th of May, was it filed with the FSL report?
Yes, my lord.
How
My lord,
could it be?
the supplementary charge sheet is dated 22nd of September, my lord.
Madam, FSL report is dated what?
My lord, 6th of September, my lord. At page 55, my lord.
Mr. Chakravarti, she is not acquainted with the facts. Not today.
My lord.
ইদুল মিয়াটা জানো? নাহলে ইদুল মিয়ার কপিটা দিয়ে দেবো তোমায়।
না পেয়েছি।
ইদুল মিয়া আছে?
তুমি
ইদুল
জানো।
মিয়া যে জাজমেন্টটা জজ সাহেব ফলো করছে।
Give him a copy.
Yes, my
Give her a copy.
আমি দেখে নিচ্ছি।
my lord. Grateful to you. আমাদের কত? 62.
I think 61, I'm not pressing this application, Your Lordship.
Very good. Not pressed.
হ্যাঁ,
62. My lord, I'm playing for no.
এইটা not present.
Wait.
Not present.
এইটা দাদা
Oh, Shahid, yeah, করবো। My lord, 63, I'm for the petition.
I am for the statement. There, see it again. A huge quantity of ganja was recovered, my lord.
My lord, I'm for the petitioner.
What is huge?
103 kgs of ganja.
That is huge.
More than 5 times of the commercial quantity threshold.
My lord, my lord, I'm covered by a judgment of this honorable court, Bapi Noshkar and another. My lord, Lordship will kindly cease, and my lord, there are.
What does it say? 100
My lord,
kg?
violation of 42(1) of the NDPS Act. My lord, will kindly comes to the cross-examination.
Here, how will be, it will be.
My lord, it is apparent. My lord, I have annexed the deposition. My lord, will kindly comes to the cross-examination of the PW1. My lord, it is not paginated since it's a certified copy. Your lordship kindly comes to the cross-examination.
No, what it was.
My lord, PW1. He is the complainant. My lord, cross-examination starts from the bottom of the page, and thereafter, my lord, it is the fact, it is the authority of the officer in charge of a particular police station to decide whether any specific case would be initiated on the basis of a written complaint. There is no endorsement on the written complaint that the same, along with the documents and the seized alamats, was placed before OC Kulpi PS. I have no knowledge that only as per section 53 NDPS Act, the OC of a PS is authorized to receive contraband substance seized under NDPS Act. That
Which page?
my lord, that is my lord, the cross-examination of PW1. My lord, may I find it out for your lordship?
No, wait, process, since lodging.
Yes. My lord, the next page there too. My lord, it is the authority of officer in charge of a particular PS to decide whether any specific case would be initiated on the basis of a written complaint. There is no endorsement on the written complaint that the same, along with documents and the seized alamats, was placed before the OC Kulpi PS. My lord, 2 paragraphs thereafter. Time true that GD number 1355 dated 28/9/2023 does not disclose in which mode I received the secret information.
Whether the secret source can be.
My lord, the next paragraph, lordship says, original GD register is shown to the witness and the witness replies that GD number 1352 and 1353 are kept blank. It is true that there are numbers of blank GDs in the original GD register. True that GD number 1355 does not mention that the copy of the said GD was forwarded to the immediate superior. So, my lord, I am covered by Bapi Noshkar where it says, my lord, where it says it is a mandate of the statute, my lord, to inform the superior, and if it is, my lord, when it was not done, my lord, the accused was given the benefit of section 42(1) of the NDPS Act.
When? At the bail.
Yes, my lord, that is what, my lord, I have handed over to your lordships. My lord, paragraph 2.
Paragraph 2.
আমার কাছে 3টে কপি ছিল, তুমি দেখো। Well, the superior is to be informed.
No, that we know. Superior has to be.
Yes.
How? Entire.
My lord, it is given, my lord, the complainant has himself stated that he did not inform the superior. My lord, it is a clear violation of subject to lordship's correction. It is a clear violation of 42(1) of the NDPS Act, subject to lordship's correction.
Yes, sir. Are you ready?
42(1) or 42(2)?
42(2), my lord. I stand.
From what I could understand from the judgment law in para 3, it says that considering the admitted position of admitted violation of 42(2) of the NDPS from the discrepancies in the written complaint.
So apart from the discrepancy.
Apart from the discrepancy. So there the bail was granted perhaps because of the discrepancies in the written complaint and not in, and that cannot be used as a precedent, my lord, because that is not set the law in motion. That was in that particular case, my lord.
I can't remember the Supreme Court decision. There is at least one decision which says that 42(2) is mandatory.
My lord.
Delayed compliance is all right, may be acceptable.
My lord.
But total non-compliance is not acceptable.
I bow down to you.
And will be a good ground for acquittal.
Acquittal, my lord, for bail.
If that is so, sir, why should we keep him in custody?
My lord, at this juncture, my lord, the trial is in full swing.
At this juncture, kindly find out that decision and come back.
I will also come back.
Also come back with a report.
Also come back with a report.
Report.
And also any decision which may be in your favor. There are decisions which say that these are factual issues to be thrashed out at the trial.
My lord.
So both of you, please do some research
My lord.
for our benefit.
My lord.
My lord, I found this only which could be subject to lordship. My lord, every day I'm learning by sitting at the feet of your lordship. My lord.
CRM number.
NDPS?
Non-compliance with section 42 of the NDPS Act,
2023
which reads as follows: 42 quote করে দিও এখান থেকে NDPS.
Order dated?
একটাই তো order আছে, 26
Paragraph, he says that he is in custody for?
My lord, the petitioner is in custody 1 year. 1 year.
1 year?
Yes, my lord.
What is the progress?
My lord,
Two witnesses have been examined. Out of 9. Proposed 9 witnesses, there are total 22 witnesses.
No.
Paragraph.
My lord, I'm in custody for 1 year, 2 months.
Custody 1 year, 2 months.
His senior officer, superior officer.
My lord, the IC or OC, my lord, should have been.
Why you have not read the first paragraph of the deposition?
My lord, first paragraph of cross-examination.
Oh, deposition.
Yes.
Chief.
My lord.
I shall help you.
Yes, my lord, on the day at about 19:35 hours, I received one credible source information from source that one vehicle with contraband substance was coming through Diamond Harbour, Kulpi Road and may reach in between 12 hours midnight to 2 hours on 29 September 2023. On receipt of the information, I diarized the fact, wide reference number, GD number 1355 dated 28/9/2023. I informed OC Kulpi PS accordingly and as per his Yes. Now, my lord, sees the cross-examination. My lord, that is the discrepancy, my lord, I pointed out.
Yes, stated on oath.
My lord,
I shall not allow on this ground. Okay.
My lord,
He informed accordingly.
My lord, in the cross-examination, my lord, he said that the GD.
He has stated it.
My lord, that has been contradicted in the cross-examination.
Decided at the time of trial, at the time of writing judgment. That is my
Subject to correction, 42 has no applicable in this case. But this is a case where search and seizure was made from a public place.
Public place.
So if it is public place, then it's under 43. So 43 non-compliance of 42 is not necessary.
My lord, informing the superior is a statutory mandate. My lord.
That is in respect of
My lord,
42.
Why did 42 applies?
When there is a seizure in respect of 42, but when it's public place, seizure is under 43.
Then
compliance of 42 is not necessary.
Consider.
My lord, I will come back on the next.
Paragraph, let the state file a report as regards the status of the trial.
Now you are learning.
Stop.
Yes, my lord, always.
Paragraph,
Always, my lord.
state also contends that since in this case the seizure was from a public place, section 42 of the NDPS Act would have no applicability and it is section 43 which will apply. Paragraph, we will consider these points on the next date. Paragraph, Thursday or Tuesday week?
My lord, Tuesday week, my lord.
Next Tuesday.
এটা নামিয়ে দিতে বলবে। Grateful to your lordship. এরপরেরটা কত? 64. 64. My lord, I am for the petitioner.
Lordship, 64 and 65 kindly not today.
65 not today.
My lord, I am for the petitioner. My lord, Idul Mia.
Dates.
66.
66. Give us the dates.
My lord, date of arrest is 25th of March 2024. My lord, charge sheet without chemical report on 10th of August 2024. My lord, I filed the bail application on the 181st day, that is on 22nd of September 2024. My lord, till date, to my instruction, chemical report has not yet been submitted.
22nd September was rejection.
Yes. And my lord, I'm in custody presently for 328 days.
Is that correct? What he said just now?
Without chemical examination report, the charge sheet was submitted, and we have not yet received the chemical examination report. And 24th of January 2025 is fixed for submission of the chemical examination report by way of a supplementary charge sheet.
24th of January 25. Issue. The petitioner prays for statutory bail, relying on the division bench judgment of Idul Mia, এটা এখান থেকে দিয়ে দেবে আবার, in CRM such and such. Paragraph. The petitioner was arrested on March 25, 2024. Stop. Charge sheet, without the FSL report, was filed on August 10, 2024. Stop. 180 days from the date of the petitioner's arrest expired on September 21, 2024. Stop. The petitioner applied for statutory bail before the learned trial court on September 22, 2024.
Yes, ma'am.
Stop. The learned trial court rejected the bail application. Stop. Therefore, the petitioner has approached us. Stop. Paragraph. APP says that when January
24,
2025 has been fixed as the date for filing supplementary charge sheet along with FSL report. Stop. The FSL report is, as of now, not available. Stop. Paragraph. It is therefore not in dispute that although the charge sheet was filed within 180 days, the FSL report did not accompany it. Stop. Upon expiry of 180 days, the petitioner exercised his statutory right to obtain bail, since complete charge sheet had not been filed. Stop. In view of the decision in Idul Mia, the prayer of the petitioner should have been allowed. Stop. Paragraph. Hence, we have no choice but to allow the petitioner's prayer for statutory bail.
I'm grateful.
Just a minute. The resident of where?
My lord, I'm a resident of Bagda, North 24 Partners.
Parasutris.
কোথায় বারাসাতে হচ্ছে মামলাটা?
Parasut PS
Remain within Barasat PS.
and meet the IO. Sorry, IO. I see Parasut PS once in a week until further.
Your relaxation.
Grateful.
Which one টা আছে?
Well, I beg to appear for the petitioner.
The state.
Mr. Sagir Ahmed and Mr. Kobir also appearing. So many matter was pending for a long time. And they are appearing and submit a report. Kindly see the last order passed by.
In their absence, why should we spend time on this? Not today. It will come up again on Wednesday. You speak to them, tell them, day after tomorrow again this will be listed.
Day after
তাই তো
tomorrow.
বুধবারে আসবে তো আবার। হ্যাঁ। আচ্ছা এটা অর্ডার রেকর্ড করো তো, নাহলে আসবে না। রেকর্ড করো তো।
আসবে না। অর্ডার না করলে
Nobody appears for the state when the matter is called on. Stop. This is an application for issuance of a writ of habeas corpus. Stop. Paragraph. Let learned advocate on record for the petitioner serve a notice on learned advocates for the state, intimating that this matter will be listed again on Porshudini date thou. Stop. On that date, if nobody represents the state, orders may be passed ex parte.
Mal. I am appearing on behalf of the petitioner.
You're appearing? Who go?
My lord, on the last occasion, my lord, your lordship was pleased to direct to submit report.
What does the report say?
The report says that the wife of the petitioner developed a love relationship with the respondent number 7. Well, they went, they left the matrimonial house and left with the respondent number 7. Subsequently, my lord, after tracking, my lord, we have found that the both of them, that the mobile phone of respondent number 7 is in operation at Karnataka, Bengaluru. So, my lord, we have traced that much. Because on last Wednesday, when the matter was called, my lord, I told your lordship that we were searching for the IMEI and all that, my lord. We have got it. But it is working in Bengaluru. Give us some time, my lord. We will be able to do something.
How much? 2 weeks, 3 weeks? 3 weeks where the chutti hui hai.
3 weeks.
Christmas vacation. So 23rd, we'll list it on the 23rd.
22nd.
22nd is Sunday.
Oh, 23rd.
Report. Kindly give him a copy of the report. Report filed by the state in terms of our order dated November 20, 2024, be kept with the records. Stop. Paragraph. It appears from the report that the missing lady has been traced to be in Bengaluru. Stop. Apparently, she has run away with the respondent number 7, with whom she is in a relationship. Stop. Paragraph. The state asks for some more time so that the lady may be produced.
My lord, the petitioner denies the allegation of love relation.
Allegation is not against you. How will you deny?
Not against me, but against
your
my wife.
No,
She is abducted, my lord.
there is no allegation. They have what? They have.
My lord, the petitioner has made the statement that his wife has fled away.
Yes, my lord.
And my lord, we have
In
videographed
paragraph,
the statement of the
paragraph
husband.
16, in paragraph 16, the sub-inspector of police compelled the petitioner to give
We
that
have
video
videographed
recording.
the statement.
That you
Paragraph
give this
as
video recording.
requested, let this matter be listed again on December 23.
December 23.
Much obliged, my lord.
Private response.
Oh,
And I appear for the private response.
Private respondent.
affidavit of service may be kept on record.
That they have admitted. You want to let my arguments.
You appear for all the private respondents?
Private respondents 4 and 5.
4 and 5.
The state, who is for the state?
Paternal.
I'm for the state lordship.
maternal
We had already
father-
submitted the report last time.
Who has gone missing?
It
The
was
minor child, Lordship.
minor child. The father was an accused in a previous case where the wife was murdered or murdered, no? Murdered, yes. We had already submitted a report to that extent, Lordship, and this
Who is
young
the petitioner? Who is the petitioner?
I am the
petitioner
petitioner,
is now
Lordship,
the
the
father.
husband.
Who's out on bail,
Yes.
who's out on bail. And the grandparents of the child had taken the child, and the child was with the grandparents. They are the private respondents.
Accusation is of he having murdered his wife.
Suicide.
Whatever it may be, you can pray for custody of the child in the appropriate forum.
Yes, Lordship, but
Child has been traced.
yes,
Not missing.
yes, Lordship.
We are not going to direct them to hand over custody to you. No, that is not the job of the habeas corpus court.
Lordship, there are certain directions of the Supreme Court. I have gone through the judgment. I can try to satisfy this court, Lordship, if the situation is for the welfare of child, and second, if they have no authority, or if it is illegal detention.
If we hold now that it is for the welfare of the child that he or she stays with the grandfather and not with the father against whom murder charge is there, will it be good for you?
Lordship,
we hold that here.
It is subject to correction, Lordship. I am accused. The trial had not even.
No, you can argue, but if we hold this, it will be difficult for you.
My lord, the welfare of the child. Now
you are the maternal grandparent or
maternal grandparents.
Maternal grandparent.
He has admitted that the child is in our custody.
Dispose of করে দিচ্ছি এটা তো।
You
You go before the appropriate forum, claim custody, get custody. But the child is not missing anymore.
The fact is, Lordship, I was not aware of that. For that reason, I have filed the habeas corpus.
Now
you are aware.
Yes, and as there is a bail condition, for that I don't even contact them, Lordship.
Do you want to withdraw it now that the report is on record saying that he is with your parents-in-law?
Yes.
You have mentioned in your affidavit that the child is
in the report you have mentioned that.
Paragraph 19.
That
they stated that child
He
is in our
himself has
custody.
stated, it's also there in the report, Lordship.
Lordship, when I was in custody, my relative informed that at some time the minor child was ill. Lordship, there was a deterioration in the physical condition. Therefore, he was admitted at Canning Subdivision Hospital by them. This was what I must be clean before this read code. Whatever I know, I must state it before this code, Lordship.
Very nice of you. Now let us dispose of this literature. Affidavit of service filed in court today be kept with the records. Stop. The private respondents are represented through learned counsel. Paragraph. We see from the report filed by the officer in charge, Kolkata Leather Complex Police Station, East Division, Kolkata Police. Report dated November 20, 2024. Filed by such and such. That the child in question, minor child in question, is in the custody of his maternal grandparents, who are the private respondents herein. Stop. The report further mentions the pendency of a criminal action against the petitioner, who is alleged to have, is 302 charge sheet?
304B, Lordship.
Who is facing a charge sheet under Inter Alia section 304 capital B of the IPC. Stop. Paragraph. We are not concerned with the criminal case. Stop. However, since the child can no more be said to be missing, as he or she, he is in the custody of his maternal grandparents, we see no reason to keep this writ petition pending. WP such and such is accordingly disposed of. Paragraph. This will not prevent the petitioner from approaching the appropriate forum, in accordance with law, if he wishes to claim custody of his child.
Grateful. Lordship, though it is not permitted, but as I have not seen my child for so long, can I see him in anywhere?
This prayer can be considerably
Oh,
custodial.
yes, that is why that court.
Not we.
Grateful,
No,
Lordship.
allow him to just.
Lordship, there is a bail condition. I cannot go there.
Allow him to see.
There is a bail condition, Lordship.
See if you can arrange a meeting because he cannot go to your place because of the bail condition. See if you can after our father. Yeah, father.
The hanging
Grateful,
of
Lordship.
commit suicide.
Hanging, Lordship.
Maybe suicide. Right. It is not a murder. Whatever. Go. Go. That's it.
Grateful, Lordship.
Not paying for not this week. Not paying for not this week.
Relaxation. Not this week. Why?
Mr. Chatterjee, sir.
That is the reason for praying not this week. Chalo, not this week.
732.
Made please, Your Lordship. My Lord, on the 23rd of February 2022, my Lord, this petitioner was released on bail. My Lord, with the condition not to enter into the jurisdiction of not 24 Parganas.
Order is at page.
My Lord, the order is at page number 10. My Lord, there are further orders also I would like to refer to, my Lord. First is page number 10, the order granting bail to this particular petitioner.
Any adverse report?
My Lord, no, my Lord, I'll tell your Lordship, my Lord, there are further, my Lord, matters which have to be placed. My Lord, now subsequently, my Lord, the de facto complainant came about for a cancellation of bail, saying that we are not complying with this condition. My Lord, may kindly takes up page number 19. 30th of August 2022 order, my Lord, before the coordinate bench.
Yes.
My Lord, we were once again told to not misuse the condition, my Lord, and it to be scrupulously followed. My Lord, and accordingly, my Lord, affidavits were directed. My Lord, thereafter, your Lordship may kindly takes up page number 22. The order dated 26th of September 2022. My Lord, every occasion the de facto complainant says that I'm not complying. So, my Lord, now
service.
My Lord, this is not a state, my Lord, case where, my Lord, which is falling within the parameters of servicing upon the victim, my Lord. My Lord, because now, my Lord, 26th of September orders may kindly cease. The superintendent of police, not 24 Parganas, was directed, if I am not complying with the condition, to arrest me. My Lord, page number 22, order dated 26th of September. In the event I'm found within the territorial jurisdiction of 24 Parganas, to arrest me. They did not, because I was not there. After this order, my Lord, I resided in Varanasi, my Lord. I have been reporting to the Lalpur police station, my Lord, every once a week. I've annexed that also. My Lord, series of orders have been passed, whereby, my Lord, this fact has been noted that I am not entering into the jurisdiction. My Lord, may kindly now takes up page number 26. 9th of January 2023. My Lord, 26. My Lord, over here, now there are other cases also registered against me when I was not there and I could not defend myself. My Lord, which is why the coordinate bench, my Lord, directed that my advocate would defend me in the event I am not present in court. My Lord, I have been out, my Lord, since the 26th of September 2022 in Varanasi, beyond the state, my Lord, and reporting to the Lalpur police station, my Lord, once a week. That is annexures 49 to 82. I've annexed everything. My Lord, the cancellation of bail. Now, my Lord, what the status of the trial is that PW1 was in the midst of his examination. At that point of time, a supplementary charge sheet was filed by the investigating agency, annexing the names of 4 more persons who are the accused persons in this case. My Lord, those orders are at page numbers 45 and 48 of this application. Of the coordinate bench, my Lord, observing this, 45 and 48.
What are you asking?
My Lord, I am asking for a relaxation, my Lord. I have been staying, my Lord, outside the state, my Lord, for the last 2 years.
What is the charge?
My Lord, charges of 302. My Lord, humble prayer before your Lordship is that the court is in Barakpur, the victim's house is in Barakpur. My house is in Noapada police station. My Lord, subject to your Lordship's, my Lord, in passing of the order, I may be restricted to Noapada police station. I will not be allowed to go beyond the jurisdiction of Noapada police station. In the event, my Lord, other than to attend court proceedings, or, my Lord, the other condition, my advocate will represent me all throughout. But I will restrict myself.
We would like to hear the.
Very well, my lord. Very,
Sir,
very
sir.
bad, my lord. Conduct is very bad.
We are not doing anything to deserve.
I will, sir, my lord.
You have made him a party.
No, my lord. I have to make him a party. Leave would be granted, my lord, for that.
Leave is granted to them. This case has a checkered history. Stop having heard Mr. Mukherjee, learned advocate for the applicant who seeks relaxation of conditions of bail, we are of the view that we should hear the de facto complainant. Stop. Paragraph leave is granted to the petitioner, applicant. Applicant implead the de facto complainant as a party respondent in this application. Stop. Let service of this application be effected on the added respondent and affidavit of service be filed in court on the next date. Where you have to serve where? Where does he?
My lord, the learned advocate, my lord, who appears for the de facto complainant in the cancellation of bail, my lord, we can serve it to him, my lord, if required.
Stop.
Because, my lord, he is regularly following up the cancellation of bail.
If he appears, fine.
Yes, my
lord. Then next Monday.
Next Monday, my lord.
Paragraph lists this matter once again on Godown.
And my lord, their report, my lord, I don't know what they have, but my lord, it is to be restricted from the 26th of, because my lord, this coordinate bench was dealing with my lord, behavior. Now, my lord, 26th of September to till date, my lord, let them show any adverse report against me.
Let us see. On that, on the adjourned date, the state should also file a report.
I'm deeply grateful.
Your Lordship, I am filing an supplementary affidavit.
Milord, it was rejected, Milord, on earlier occasions, Milord.
That's I am
On the
submitting
ground
my
of
client
Milord,
application.
the wife being pregnant, Milord, he is asking for relaxation. Milord, out of 5, Milord, 2 witnesses are yet to be examined, Milord. He is in Odisha, Milord. If he goes away, Milord, he will have specific objection that he may not be available to attend the trial, Milord. The trial cannot be completed. And, Milord, he has annexed an order sheet, Milord, wherefrom it appears, Milord, that 29th, Milord, one day, Milord, witness was not present. And, Milord, on 29th, Milord, I don't find any date for examination of witness, but, Milord, production of one of the accused persons and hearing of bail application. I do not, Milord, I have not been instructed when is the last date, next date for recording of evidence, Milord. The 2 witness, Milord, if your Lordship so, Milord, please, Milord, kindly direct us, Milord, so that we can complete it within 1 month from the next date of it.
The last witness examined.
Because
by the
difficulty is that had it been in
prosecution was on 13th of August.
Milord, had it been in West Bengal, Milord.
Allow him to speak.
My lord.
The last witness was examined by the prosecution was on 13th of August. I filed a supplementary affidavit, kindly running page 4, annexed F. After that, 14th of August, 12th of September, 7th of October, 11th of November, and 29th of November, no witnesses were present.
Out of that, Milord, presiding officer was on leave, Milord. Kindly have a look.
You must be present there. Then
That
coming to the court, you will know.
No, Milord, that is correct, Milord. The PO is on leave, Milord.
Your witness was present there on that day.
Milord, on the last occasion, Milord, kindly have a look at Milord 7th, Milord. 7th October, Milord, no witness was present, Milord. And Milord, thereafter, Milord, 29th was, Milord, date fixed.
11th of November was also.
On 11th, Milord.
Was present, but PO is only.
Yes, on 11th, Milord, the PO was on leave, Milord. PO was on leave, Milord.
Witness present.
Yes. Now, Milord, 29th, Milord, that the date was fixed, Milord. On that.
Mr. Maiti, we'll grant you time till January, middle January or something. Complete the examination of your interested in protected witness.
No, Milord. The other 2 witnesses, Milord.
2 witnesses are remain.
Independent witnesses.
Independent witnesses.
Caesar list witnesses.
So you complete that.
My lord.
Family way.
Huh?
He is in the family way.
Who?
I have supplemented.
Milord, if he goes to Milord, Odisha, Milord, if in the midst of that trial, Milord, then trial may be frustrated.
Complied with the condition for the last.
Let him wait
years.
for. Yes, earlier petition was rejected. Earlier petition was rejected. Kindly have a look.
Delivery of.
The child has been delivered. Delivered in the month of November.
So let him, Milord, wait for some time, Milord, then we can complete it.
I was not able to go at the time of the delivery of
Then
the
let
child
him, Milord,
because of
wait
the
for.
complying of the condition of
At
this
least let him wait for 2 months.
I have
We will
not seen
complete
the
it.
face of the child since his birth.
That may be, Milord, with through video conference.
Ground that I have not been being the father, I have not been able to see
Yes.
face of the child.
But had it been in West Bengal or Milord, somewhere else, Milord, then you could have considered.
However, in the
If he
report
goes
filed
to
on the
Milord,
earlier
if he
occasion,
goes to Milord, Odisha Milord, now the factual scenario has changed, Milord.
kindly
On
come
the
to
ground,
report.
yes,
You will conclude the trial within 2 months.
yes, Milord, kindly record it.
To
Milord.
record your submission.
Yes,
We'll keep this pending. We are not
yes,
rejecting.
yes, Milord.
Yes,
And I will communicate this order to the learned trial court, Milord.
They have filed
So that,
the
Milord, within
evidence
2 months,
for
Milord, within
evidence.
2 months, Milord,
But
2 witnesses may be
yes,
examined,
kindly consider the
irrespective
report
of any.
No, witness examine or conclusion of trial. What are you
Milord,
saying?
witness of examination means, Milord,
It
argue for.
doesn't mean that. Then there is 313, then there is argument. There are a lot of things after that.
Milord, kindly fix it about 2 months from the next date, Milord.
I am not fixing anything. We'll
My
be
lord.
recording your statement that within 2 months, the trial will be concluded.
My lord. And the trial court is to proceed on the basis of this order to be passed by this honorable court.
But
You are not producing witnesses, then.
Milord, that's why, Milord, I am submitting, Milord, kindly let the order be there to that
file,
effect.
your lordship kindly consider the report filed on the last occasion.
Now he is to want.
The
Custody.
I
No, no,
was
no.
in
He has been released on bail.
on bail for the 2 years.
He has been released. He released on bail, Milord. He wants to, Milord. The ground was that, Milord, his wife is pregnant. He wants to be to give the company. Now the child has been delivered. Let him see the face of his child, Milord, over video conference, Milord. That, Milord, does not entitle, Milord. That had it been in Odisha, Milord, I could have, Milord, shown that, Milord.
The petitioner was granted bail by an order dated November 17, 2022.
2020.
Passed in CRM NDPS 1.
Three witnesses have already been, 2 witnesses are yet to be examined.
2022. Inter alia on the condition that he shall not leave the district of Howrah until further orders, except for the purpose of attending court proceedings. Stop. He now seeks relaxation of that condition of bail. Stop. He says that his wife has delivered a baby at his native place, i.e., where is the village? What village?
Village in Khordha, district Khordha. He is a resident of district Khordha.
District Khordha, Odisha.
Odisha.
Yes.
Stop. He hasn't seen the baby. Stop. He has adhered to the conditions of bail for the last 2 years. Stop. He will continue to do so. Stop. Paragraph strongly opposing the prayer for relaxation, learned, you are for?
NCB, Milord.
NCB, learned advocate for NCB, Narcotics Control Bureau, says that if the petitioner is allowed to leave the geographical limits of Howrah and permitted to go to Odisha, it is very likely that he will not come back to face the trial. Stop. Only 2 witnesses remain to be examined. Stop. The prosecution hopes to. Now, prosecution is pretty much sure that the trial can be concluded within the next 2 months.
On the next date of Milord evidence.
Within 2 months from the next date fixed for hearing. Stop. Paragraph. What was recovered? Ganja?
Yes, Milord.
Not from me.
Yes, yes.
Not
Milord.
from me.
How much quantity involved?
Milord, commercial quantity.
Commercial to 20,
Yes.
very commercial.
And Milord, earlier petition was rejected, Milord.
It was not recovered from me.
It was rejected, Milord, earlier.
Paragraph 4, learned
The same
rejected
prayer was
by order dated?
Milord, by order dated
27th of September 2020.
Next date.
Yes.
Yes, Milord.
Page?
Milord, that is, Milord, page. Here's not paginated, Milord.
Yes, yes.
That is 27th in my petition.
That is annexed.
Condition directing the representative to remain in the Howrah district was
27th
imposed
of page, annexed C, page 12.
so that he may not abscond during trial. We do not find any reason to relax the said condition.
27th of
September 2020.
2023.
And a direction was also given to conclude the trial within a year.
That was not done.
That was not done.
Next date from the date of trial, Milord. So, Milord, within 1 year it is there.
Within, it has surpassed the
Learned
1 year
advocate,
period.
also refers to an order dated September 27, 2023, passed in SRM NDPS, CRM NDPS 1319 of 2022, whereby the petitioner's prayer for relaxation of the condition of bail restricting him to the territorial limits of Howrah, was rejected. Stop. Paragraph. Having heard learned counsel for the parties, we are of the view that immediately the concerned condition of bail may not be relaxed. Stop. Particularly, stop now. Particularly in view of the assurance meted out by learned advocate for NCB that the trial will be concluded within 2 months from the next date fixed by the learned trial court. Paragraph. Shall we dispose it of or keep it pending?
Can you dispose it of otherwise?
You can come back after.
Kindly, if the attendance before the local PS be made once in 15 days.
We are asking you something else. Shall we keep it? You can come back. We'll grant you liberty to come back for relaxation.
My lord, one prayer, if the attendance before the local PS be made once in 15 days.
Let him come back if he cannot be complied with.
Apprehension is when you go out of West Bengal, he will not come back.
And that was the finding of the earlier coordinate bench.
Okay, liberty to come back. Stop. You will within 2 months from the next date fixed by the learned trial court. Stop. Paragraph. Accordingly, we dispose of this application by granting liberty to the petitioner to renew his prayer for relaxation of conditions of bail after 2 months from the next date fixed for hearing by the learned trial court in view of the assurance granted on behalf of the prosecution.
On instruction, my lord, kindly say.
Naturally, everything you say is on instruction. Disposed of. नहीं. 7:35.
Yes, ma'am. We are appearing for the NIA, my lord. This is the report which your lordship will please. Notes of arguments, my lord.
For the petitioner. Well, a report may be handed over to me also.
Give a copy.
Got a copy.
Lekho, Abhijit. Report filed by NIA be kept with the records.
Notes on arguments, my lord. So for objection, containing objection against, my lord, relaxation of condition of bail.
The approval from the higher authority could not come.
No. So this is what you are filing.
Yes.
Well, not report. Notes of argument. Report kado. Notes of argument filed on behalf of NIA be kept with the records. Stop. Let a copy of the notes be made over to learned advocate for the petitioner. Paragraph. When?
Next Monday. Next Monday, my lord.
List this matter once again on Shamne Sombad Diya.
Deeply obliged.
What is the condition you are asking relaxation?
Lord, condition was that
My lord, there was a condition, my lord. I was asked to submit my license.
No,
that order has been recorded. It's my.
He was not asked. He voluntarily surrendered because the court was reluctant to grant bail on the my lord ground that if the licenses are not surrendered, they may carry on the same type of business in Mohammed Bazar police station. That's why they voluntarily, my lord, undertook to, my lord, to surrender the licenses.
Very well.
So there cannot be relaxation if he voluntarily, my lord, surrenders anything. Court did not impose any condition. And apprehension is that, my lord, same, if the license they have got, then they will carry on successful. Your lordship is in season of the matters.
Yeah, he can pray for duplicate license.
No, my lord, there are some procedures, my lord. My lord.
Me.
Well, I'm for the state, my lord.
My lord, I'm for the petitioner, my lord. My lord, I'm renewing my prayer for relaxation, my lord, for the third time. This is my third application, my lord. Yes, my lord. My lord, the petitioner
What
was
is that report?
The report, my lord. My lord, para 4, my lord. Can you once go through the para 4, my lord?
Allow him to speak.
Adverse report.
The only month of November attendance it has been found by the, my lord, the investigator officer, my lord. Only month of November, my lord.
My lord, I have all the.
He has to take
I have the original, my lord.
You have a copy of the report?
No, my lord, no, my lord, no.
You want to consider the
Yes,
report?
yes, my lord, yes.
Give him a copy. This is an application for report filed by the state be kept with the records. So a copy of the report has been made over. Let a copy of the report be made over by learned state advocate to learned advocate for the petitioner in course of the day. Stop. Paragraph as requested by learned advocate for the petitioner, comma, let this matter stand adjourned and be listed again on Monday.
Monday, my lord.
Monday date diye dao. Monday date diye dao.
My lord.
My lord. 1138, my lord. I am for the petitioner.
State is not. State.
Last of it, my lord has directed to file one supplementary affidavit. But my lord, due to some procedural problem, my lord, I could not serve. My lord. This is my supplementary affidavit. Let it be kept inside.
How many? Do copy ache dekho. Who is appearing for the state?
My lord, on the last occasion, one Mr. Iqbal Karim was appearing for this case. Iqbal Karim.
Is he there today? No. Have you seen him? No.
I have seen it, my lord.
Anyway, supplementary affidavit filed on behalf of the petitioner be kept with the records. Paragraph, the state is not represented. So let a copy of the supplementary affidavit be made available to learned advocate for the state. Stop. This matter once again, day after tomorrow. Budwar, this.
My lord, I am for the petitioner. My lord, I am praying for the relaxation of condition of bail of the order dated 1st of September 2023.
Report not to enter.
My lord, not to leave North 24 Parganas and Kolkata, shall provide the address where he shall presently reside, and to meet the NCB officer once in a month to deposit the passport before the court below. My lord, I have met the NCB officer. I have annexed my attendance copy to the petition. My lord, page 10 onwards. I have not left North 24 Parganas and Kolkata as well. And my lord, I cannot go abroad because the passport is now deposited with the court below.
Any adverse report against him?
Kindly call for a report. Yesterday we have received.
Oh. The petitioner seeks relaxation of conditions of bail that was granted to him on September 1, 2023. Stop. Paragraph, let the state file a report.
From the narcotic control.
Union of India, madam.
Oh, not state.
NCB.
Let the Union of India file a report to the Narcotics Control Bureau as regards the conduct of the petitioner. When next Monday?
As you know.
Will you be able to do it as your lordship?
The copy. Well, wait is that.
Day after tomorrow.
Wait
Wednesday week.
Honestly.
Please this matter once again on করে দাও Wednesday week এর তারিখটা দিয়ে দাও. First time you're asking for relaxation.
My lord, first time. I'm grateful. Your Lord.
No.
My lord, this is a prayer for relaxation of condition of bail.
I'll file a report, my lord. I have already sent the mail, my lord. Kindly adjourn it for a week, my lord.
On the last
Cancel,
occasion,
cancel.
the learned senior friend also asked for time. And my parents are ill. I have not been able to go back to my
All right. Let him wait
home.
for.
Where?
Malda. The case is of Dakshin Dinajpur. I have been restricted to Murshidabad.
দেখি কি ছিল?
My lord, lastly, I have, my lord, sent the mail on, my lord, 29th, my lord. On Friday, my lord.
Oh, already you had sought more time. This is peremptory, Mr. Maiti.
My lord, on 29th itself also I have sent mail, my lord.
We are not
Now this is
bringing
a
you-
difficulty is a bifurcation of the, my lord, jurisdiction, my lord, in both, my lord, that North Bengal and, my lord, this is the administrative problem, my lord. Still then, my lord, kindly have a look, my lord. I have, my lord, left no stone to unturned to have the receipt of the receipt
November
report.
20, 2024, NCB had
Kindly fix
obtained
up on Monday, my lord. I will do it.
extension of time to file report. Stop today again. Further extension of time is being
On
sought for.
29th, my lord, I have sent mail.
Again, take it to the sought for paragraph as a last chance, comma. We adjourn this matter till next Monday, করে দাও.
My lord.
So, the report must be filed on or before that date with advance copy to learned advocate for the petitioner.
Deprioritized. Yes, it is. Reported copy of the petition.
My lord, I am the applicant over here and the opposite party in the cancellation of bail application. What had happened was there was a case which was initiated under section 302 on the ground that it was a poll-related violence case. My lord, the proceeding was taken over by the CBI. My lord, thereafter we were arrested and we were granted bail. My lord, against that order of grant of bail against 11 persons, my learned friend's client, the de facto complainant, moved this honorable court. My lord, while the hearing was going on, my lord, there was an additional condition which was imposed by this honorable court on the 6th of October 2023, asking them to not to enter the district of Purva Mednipur. Now, in the midst thereof, the CBI had approached the Honorable Apex Court, praying for transfer of the cases beyond the territorial jurisdiction of the state of West Bengal. Subsequently, in October, that was withdrawn. September, that was withdrawn by the CBI.
Stay stands lifted.
Stay stands lifted. Now, we were in. Malad, there are total 42 accused persons. Out of that, except us, 11. And 2 persons against whom warrant is pending. All others, about 28 persons, have been are staying within the jurisdiction of Purva Mednipur. In fact, the 20 persons who approached this honorable court praying for anticipatory bail, they were given the condition that they should not leave the district of Purva Mednipur. My lord, in our case, we have been complying with this order for about nearly 1 year, 2 months, 14 months.
Your report.
Yes, my lord. We are submitting our report, my lord.
Kindly seize the report.
My lord, last supplementary charge sheet has been filed, and my lord, the copies have already been supplied, my lord. It is on the process of now, my lord, further process of trial, my lord.
Well, kindly seize paragraph 6.
My lord.
They are complying with the condition.
Yes, my lord.
My lord,
Yes, my lord.
They complied with their.
No, my lord, my lord, then my lord, kindly have a look at my lord, our report, my lord. That is at paragraph, my lord, 6, my lord, which we have taken, my lord. Because, my lord, most of the witnesses, my lord, is within the jurisdiction of Nondigram police station or the neighboring area, my lord. So our apprehension is that, my lord, the persons, my lord, the postpone violence case, my lord, if it is, my lord, they enter the jurisdiction, my lord, there every chance of tampering with the witnesses, my lord, when the trial is
28
going to
accused
come.
are staying within. Kindly seize this.
My lord, in this case, it was my cancellation of bail. My lord. The learned sessions court was pleased to grant bail, more specifically, my lord, to the respondents 3 and 13 on the ground of medical condition.
No,
Now,
no.
my lord, they did not annex any medical document. That was the point, my lord, along with the other points of the coordinate bench rejecting the bail application and the sessions court granting the bail without considering any of the basis on which the coordinate bench rejected the bail application. My lord, the cancellation of bail application was being pending. It was being argued. My lord, during that time, my lord, since the argument could not be completed right before the Puja vacations, my lord, at that point of time, my lord, it was said that till the hearing of the cancellation of bail application, they are to stay outside the jurisdiction of Purva Medipur. Now, my lord, in spite of that condition, my lord, the petitioner, the complainant, my lord, has been threatened. My lord, attempts have been made, my lord, on her life. Criminal case was started. My lord, criminal case was started. The police hurriedly filed an FRT. My lord, we then made a prayer for further investigation. We have annexed it to our, my lord, opposition to their, my lord, relaxation of condition of bail, my lord, where we have stated in paragraph, page number 13, my lord, the
How
court,
you have been attacked?
my lord, these accused persons, my lord, they've come, entered, and they've attacked. And my lord, the court was pleased to
And it was
direct further
found-
investigation. My lord, Lord kindly takes up that order.
How you can show that they have entered?
My lord, I have been, my lord, this is my case. I have been attacked. My lord,
Have you filed?
my lord,
Yes, that was, my lord,
Well, kindly ask my learned
specific
friend to
order
produce
was
the FIR. It does not name
specific
us.
order was recorded by the coordinate bench of this honorable.
This is the exceptions to the CRAN application which has been filed by them. My lord, we've already put it on record.
Specific objection was taken on behalf of the repair complainant and us also.
Filed in
my lord.
opposition to the
An
grant.
order was recorded, my lord, to
FRT
that
has
extent,
been
my lord. Order
filed
was
by the
also recorded,
police.
my lord, by the coordinate bench to the
How is
CPEC,
the
my lord,
FIR?
and it ended in final report that was challenged before the, my lord, magistrate, my lord.
আর কি বলছে অপোজিশন ফাইল করেছে
Yes,
গ্র্যান্টটা এখানে তো কিছু নেই আর
My lord, this is opposition. We've already handed it over.
So FIR is sufficient.
Lord, FIR, my lord,
Just a minute, I have to ask Mr. Mukherjee.
Yes,
In the first half, I used to ask questions to senior Mukherjee. Now I am asking the junior. Whether investigation was done, that they have entered into the. Why then police did not arrest them?
My lord, now, my lord, what would be shocking?
My lord,
One order.
kindly seize the FIR. Yes.
Seize the order, my lord, which has been passed by the
I do
London
not
Magistrate.
know. Police is
This is
making
investigated by the
investigation.
CBI.
that is investigated by CBI.
You have to arrest them.
But CBI has to, but
Yes.
I am, but police, the case was taken away from the police to the CBI. Now, but CBI was to do these steps.
You lost the FIR to
With the concerned police station where FRT was submitted. Now, the learned magistrate said that he is dissatisfied with this investigation which was done by the
And
police.
challenging that order,
And challenging
that order, application was made for
kindly
further
seize the
investigation.
FIR.
That was
Does
brought to
it
the
name
notice,
these persons?
that was brought to
Does
the notice
not.
of this honorable court bench.
FRT was
Yes.
filed by the police. No, my lord, further investigation allowed. My lord,
My lord,
further
further
investigation allowed.
investigation was allowed, my lord.
Further investigation
That
allowed.
report we have filed, my lord, before the
I can
court
hand over
bench.
to
But kindly seize the FIR. It does not name us.
My lord,
Yes, yes.
It is against
order
one
of
Sheikh
the accused
Shahuddin.
One
I
of
am
the
not
accused
Sheikh
person.
Shahuddin.
This is the
Maybe
order.
one of the
Directing
accused.
further
The
investigation.
order is fine, but where is FIR is page 17. Kindly seize. I've got that. Matlab, this is the response to the CRAN filed by the OP number 3 and 13. What they have, Matlab, your lordship can see the FIR.
Mr. Ganguly, let us try to find the papers first. Mr. Mukherjee, the papers are not traceable.
My lord, then
He has must not have filed
Continuous
it.
papers are there, my lord. So many affidavits have been filed, reports have been filed.
Sort out the papers, come back
Yes.
day after tomorrow.
Day after
Please
tomorrow.
come back
My
day
lord.
after.
Mighty.
Hey,
Yes.
ওই আসবেন ও জুনিয়র আসবে পেপার গুলো
Kindly seize page 17. That's the FIR.
Let the paper be arranged, we will come back, my lord. Day after tomorrow, so that.
File the report today.
Yes. Lord, one
Page
of the accused,
17.
my lord. One
Kindly
of the
Yes.
and 6-7 others. My lord.
And they don't know him.
and 6-7 others.
The Ranjit is the brother.
And he has said, he has identified everyone by name in the 161.
Such an অপরিচিত ব্যক্তি, why you have not mentioned by
My lord, that is for the investigation.
Oh, that's what.
By CBI. Be kept with the records.
investigation
Paragraph.
done on the basis of
Heard
FIR.
learned counsel for the parties at some length. Stop. List this matter once again on day after to pursue the date দিয়ে দাও, comma for further hearing.
Well,
My lord, we will
Sort out the papers.
yes, deeply.
So many orders have been passed also, and we have filed the
কেবল
affidavit.
আমাদেরই দিচ্ছি।
Reports have been
Job
filed
type
and
দিচ্ছি।
supplementary, last supplementary affidavit filed, my lord. This is a post-poll outcome of post-poll violence, my lord, having, my lord, political support of the ruling party.
And 28 accused persons are inside and there is no allegation against them. No cancellation prayer.
No, cancellation করা হয়েছে। করা হয়েছে। Deep knowledge, no?
My lord, may I be permitted to take back the office for?
আচ্ছা, ওটাও নিয়ে নিলি?
না, তাহলে তো আমার কাছে কিছু থাকবে না।
ওইটা এটা সিবিআই রিপোর্ট ওটা না এটা নিয়ে সিবিআই রিপোর্টটা তো কোর্টে রেকর্ডে থাকে আমার ডিপি
I'm for the petition.
Which was the other side?
My last question, there was a direction to file supplement.
There was a direction to file a supplementary affidavit. Are you sure? We had directed you.
Leave granted to the petition.
Is it the same thing?
The copy was
File supplementary affidavit filed by the petitioner be kept with the records. এটা কত নম্বর হচ্ছে ভাই? Keep with the records. Rob, let a copy be made available to learned advocate for the state. Paragraph list this matter once again day after tomorrow. পরশু দিনে দিয়ে দাও. Inform your other side. Who is appearing?
line inform.
Yeah. Paragraph, since the state is not represented today, comma, let this order be communicated by learned advocate for the petitioner to learned advocate for the state.
Since 7/3/2023, I am meeting the local police station once in a week.
You now want to meet once in a month?
It may kindly waive to charge sheet is submitted, and all the offences are triable by magistrate court.
This is the second CRAN application. This is the order of the first CRAN application, where they did not comply the order of this honorable court for the 4 months. And this is the report. After that, the High Court order has been passed on 3rd of July.
I have annexed. All the Hajira I have annexed.
Well, third paragraph. This is the report.
No, the order says you were not meeting the IO.
Hajira Khata is annexed.
In the Hajira Khata also it shows that.
Coordinate bench has recorded that.
We do. No, today is student. All matters are withdrawn. For my
You can't bill for that.
50%.
Is there any necessity to meet Thana Hajira?
We directed. You have to.
That's right.
When
That's
we have
right.
directed, you have
When a charge sheet submitted, triable by magistrate.
Then you can move for modification.
3/7.
You yourself decide. It is
No,
not
that's
necessary.
not.
That is your question.
My annexure, kindly see my annexure. It is last, my lord.
Where is
the month of October?
There's an adverse report against you. You shall not allow.
Where is the bail order?
It is the stamp.
Last page,
It is the stamp, my lord, put by the local police station. 3/7/2023.
Where 3/7/2023 is stamped. 18/11/2023. Kindly see the stamp.
No. Last stamp. 9/20.
We can relax to the extent
Yes,
that
9/20.
report once in a month, Mr. Kaur.
Yes.
What is the stage of the trial? Well, 3 witnesses has been examined out of 14. This is a case of trafficking is also involved. 2 minors has been.
He is attending court.
Yes.
attending the court, my lord.
Once in a month is sufficient. The petitioner was granted, petitioners were granted bail by an order dated July 3, 2023, inter alia on the condition that they will report to the investigating officer, CID, once a week until further orders. Paragraph, the petitioners say that they have been complying with all the conditions of bail. Stop. They seek relaxation. They seek waiver of the aforesaid condition. Paragraph, if I file the report today,
Yes, ma'am.
the state files
State, ma'am.
files a report. Stop. Let the same be kept with the records. What is your report?
My report is that, my lord, what is in the order also, first 4 months he did not comply, subsequently comply.
The report is to the effect that for the first 4 months after bail was granted, the petitioners failed to comply with the conditions of bail. Stop. After that, till date the petitioners are complying with the conditions. Paragraph, in that view of the matter and seeing that trial is in progress and 3 out of 14 charge sheet named witnesses have already been examined, we modify the aforesaid condition to the extent that it will be sufficient for the petitioners to report to the investigating officer, CID once every month until further orders. So all other conditions of bail remain unaltered. Disposed of.
For the petitioner, my lord. My lord, relaxation of State was there on last petition.
State doesn't like you. You have appeared, state has disappeared. What can be done? Who is appearing? Who?
He is in bar association room number 12.
Go and get him.
We share the same bar actually. So that is the reason I'm aware.
So you are raising objection against.
Yes, my lord.
My lord, case counter case.
Let the state come in the absence of the state. We have to seek a report from the state also, whether you have been complying with the conditions. The state is not represented. Stop. Let this matter be listed again on day after tomorrow. Tarikta Diyada. Stop. Learned advocate for the petitioner is requested to communicate this order to learned state advocate.
Much obliged.
Item 745. And I will prepare for the petitioner.
Who is appearing? Madam, in 745, who is appearing?
Praying for not today. Yes, yes.
Day after tomorrow.
Day after tomorrow.
You are for the state?
No, my lord, I'm for the customs department.
Customs. Yes.
Complying with regularly. Female accused.
Any adverse report?
There is no such adverse report, but if your lordship directs us, we shall file a report within a short period of time, maybe within a week's time. So for whether he has complied with the other conditions or not.
Customs is there.
I'm customs.
He is customs.
Oh,
the petitioner seeks
female accused, my lord.
Yes. Next Monday,
Female
file a
accused,
report.
Thana Hazira, local police station Hazira, my lord, is not permissible.
It's not local police station, it is Hajira before the custom officer.
Whatever it
As
may
per
be,
the order, he
the
has.
Supreme Court verdict is there.
Before
Supreme Court
customs
verdict is-
officer also we cannot do.
Custom officers are not police officers.
But investigating officer, we have
Whatever
the-
show us that.
But right now I have not, my lord.
Come back next Monday. You also file a report by next Monday. The petitioner.
Also kindly makes it on Tuesday, lordship. Next Tuesday.
Relaxation is not then Wednesday week.
Wednesday.
the petitioner was granted April 24.
Yes. April 24.
Was granted bail. What are the charges?
But allegation is that hashish was recovered from her 6 kg from her bag while she was traveling abroad.
The petitioner was granted bail by an order dated April 18, 2024. Inter alia, which conditions you want us to relax?
Only meet the customs.
Inter alia on the condition that
Other condition I want to put.
After 7 years,
he shall report to
After 7 years, I have been granted bail.
the
After 7
air,
years.
block capitals AIR, Customs Superintendent, comma, Air Intelligence Unit, bracket AIU, bracket close, comma, NSCBI Airport, once every week until further orders. Stop. She seeks relaxation of this condition of bail. Paragraph, what is that?
Every copy. Till to date.
Let the Customs Authority file a report as regards the conduct of the petitioner and as to whether or not she has been complying with the conditions of bail, on or before the next date, comma, with a copy to learned advocate for the petitioner. Paragraph, list the matter once again on সামনের সপ্তাহে বুধবারের ডেটটা দিয়ে দাও। হ্যাঁ 11.
Grateful to your lordship.
I love Lester.
May it please your lordship. I am praying for the my lord, with great respect, I submit. On the last occasion, Mr. Nandi had opposed it on the ground that charge, if framed, he has no objection. My lord, charge has been framed. We have the documents. Now today he prefers not to be present. My lord, this is with great respect very unfortunate.
Yes, Mr. Ganguly, only day after tomorrow, because if he's not there, he'll be there. Day after tomorrow, he'll be there. Madam, day after tomorrow, if he's not there, kindly make other arrangement. Not fair. Not fair.
But may it be as to be mentioned, because ছিল তো কোথায় গেল বাবা এত ব্যস্ত
It will be at the top of this list at 3 o'clock.
I'm deep.
Hey, the accommodation is paid for. Eta diye dao. Accommodation is paid for on behalf of the state. Paragraph, learned Mr. Ganguly, learned senior counsel representing the petitioner. Petitioner says that charge has already been framed. Top. Paragraph, list this matter once again on Porshu Diner Tarik Dao as the first item under the heading relaxation of conditions of bail.
Deep. তো কাগজটা রেখে দিন তাহলে রেকর্ড ডিপ
রেখে দাও।
দাদা অরিজিনালটা দাদা
হ্যাঁ
दादा दादा ओरिजिनल लगते हैं क्या ओरिजिनल भी लगते हैं क्या रिपोर्ट में मैडम आपको
কোনো প্রবলেম
I am for petition.
State.
I'm
Gotcha.
state in this one.
Lord, order this 21st June, my lord. Not to enter the Sakhail PS and petition 2 and 3 shall report the police officer, my lord, once every fortnight, my lord. I comply the report. Kindly see the exercise book, my lord. Can you see?
Yes, what is your instruction?
My lord, as per the report, they are complying with the order passed by the
Complying.
honorable. My lord, this is the report.
So shall we relax?
My lord.
302. What is the stage of the
My lord.
Charge frame.
We have
Charge only.
Charge
intimate
only
you
frame,
with
as per
this.
the instruction.
So within 4 months,
Yes,
you
my
have
lord, in the
straight for
order was
decision.
passed in.
My lord, 6, now 21st June, my lord.
When no-
21st June order.
5 months?
And
5
it
months,
was
my lord.
The
I
application.
comply
was
the
in
order, my lord.
Month of September, which is
What
3 months.
comply for 1 year at least, we will then see.
That is the only thing.
My lord,
Otherwise,
petitioner number 2 is a senior citizen, my lord.
You can intimidate. You can intimidate the witness. There is a,
What we can
6
do,
months, my lord.
reporting to OC টা আমরা করতে পারি once a month. We can relax that once a month, but the Shakrel you are not going to enter now.
My lord, petitioner 2 is a senior citizen lady, my lord.
whatever it
He is suffering very, my lord. Annex the medical report, annex. Kindly see the
Whatever it
page
is.
12, my lord.
302.
My lord, between the family, my lord, 100 days, my lord, please to release the bail. Only 100 days, my lord.
only 2 can be granted.
Only 2 can be granted. Huh?
My lord.
Issue.
A month, my lord.
বাকি সব reject হবে।
Right.
Once, you know.
Once in a month. The petitioners who are before us,
4 verses.
petitioners were granted bail by an order dated June 21, 2024, inter alia on the condition that এটা কি আমরা দিয়েছি নাকি? ও,
দিলাম বেল তারপর আবার এই সমস্ত।
that they shall not enter the jurisdiction of Shakrel police station until further orders, and that the petitioner numbers 3 and 4 shall report to the officer in charge of the said police station, of the jurisdictional police station, where they presently reside
At Pachla PS.
Once every fortnight. Stop. They now seek waiver of the aforesaid 2 conditions of bail. Paragraph. The state files a report, let the same be kept with the records. Paragraph. The petitioners are facing charge of murder. Stop. However, we are told that charge has been framed. Stop. Petitioner number 2 is a senior citizen and a lady.
My lord.
Stop.
One also a lady.
We
my lord.
find from the one also lady.
My lord.
No.
But not a senior citizen.
No, my lord.
Stop. We find from the report filed by the state that the petitioners have been complying with the conditions of bail. Stop. However, given the gravity of the charge, we are not willing to, we are not inclined to waive the condition restraining the petitioners from entering Shakrel, jurisdiction of Shakrel police station, excepting the petitioner number 2, who is a senior citizen. Stop. In other words, the petitioner number 2 may be permitted to enter the jurisdiction of Shakrel police station. Stop. This relaxation will not apply to the other petitioners. Paragraph. Insofar as the direction on the petitioner numbers 3 and 4 to report to the officer in charge of the jurisdictional police station is concerned, it will be sufficient for them to report to that police station once every month instead of once every fortnight. Paragraph. All other conditions of bail remain unaltered. Disposed of.
শুরুই হলো না, আমি ইন্টিমেডিয়েট তো আপনি
Now for this.
Please, your lordship, my application, my lord. My lord, earlier this matter was filed, we moved to your lordship, my lord, and that time due to some technical problem, my lord, that was withdrawn. Leave was granted to file a press. With that leave, my lord, I am pressing this application, my lord. My lord,
my lord, the condition was that he shall live within the jurisdiction of the concerned police station. I have a talk with the IO. He said that he's staying inside the jurisdiction, but no report has been, my lord, sent by them.
Not necessary.
My lord, paragraph page number 10, I have to stay within the jurisdiction of Diamond Harbour.
Diamond Harbour Police
But
Station. He's
what I am
staying.
submitting
Yes,
before,
my lord. He has
what I
his
am
residence over there.
submitting before your lordship is a case under section 306. The present petitioner before your lordship was, my lord, a employee or, my lord, a constable of Calcutta Police, my lord. For that case, he was in custody, my lord. Departmental proceedings was drawn up. My lord, his salary has been deducted, and my lord, annexed to all some documents which he has been gathered. Against that, my lord, he have to file an appeal because, my lord, he's in departmental proceedings. He is now not in a position to give this answer of the so cause or come to Kolkata. That's why, my lord, I pray before your lordship, beseeching before your lordship to allow me to, my lord, to enter in Calcutta or otherwise, my lord, to free from, my lord, the Diamond Harbour, my lord. Because, my lord, I am now confined in Diamond Harbour jurisdiction.
Case, what is the case?
Case of 306.
306, my
Case
lord.
is pending where?
At Diamond Harbour.
Diamond Harbour.
Diamond Harbour.
ওখানে case is opening আছে।
ওখানে
we can allow his prayer.
You can only
But my
come
lord,
to
that was the only condition. Some condition may be there, my lord.
No, other condition I am not asking for
Shall
anything.
not
before the trial court,
Yes,
each and every hearing.
I am not seeking anything.
Trial has not yet been started.
Yes.
So far as my
That
instruction
he
goes.
shall remain within the jurisdiction of the concerned police station. I am just precising before the lordship relaxation on that part.
You want to come to Kolkata?
Kolkata, South Chowbis Pargana to Kolkata. Through South Chowbis Pargana, I have to enter Kolkata, my lord. Otherwise, I can't.
What is it?
Just a minute.
Appearance, charge. My lord, so far as my instruction goes, I stand corrected. Charge has been framed, my lord.
Yes.
You are facing departmental proceeding.
Yes, my lord. I have to annex, my lord, the document, page 12. My lord, half my salary has been already deducted.
The petitioner was granted bail by an order dated June 26, 2024, inter alia on the condition that he shall remain within the jurisdiction of Diamond Harbour Police Station. Stop. He now seeks a relaxation of that condition. Stop. He says that departmental proceeding has been initiated against him. Stop. He was a constable in Kolkata Police. Stop. He needs to have access to Kolkata to contest the departmental proceeding. Paragraph. Learned state advocate says that charge has already been framed. Stop. There is no adverse report in so far as the petitioner is concerned. Stop. In other words, the petitioner seems to be complying with the conditions of bail. Paragraph. In view of the aforesaid, we are inclined to allow the petitioner's prayer. Stop. The petitioner is permitted to leave the jurisdiction of
Diamond Harbour Police Station.
Diamond Harbour Police Station only for the purpose of coming to Kolkata for the purpose of taking care of the departmental proceedings. Yes. The other conditions of bail remain unaltered.
Grateful, my lord.
Grateful, my lord. Deeply.
Taking care of Corona, attending to the department.
My lord, I am for the petitioner, my lord. Yeah, my lord, the bail was granted by your lordship on 26 June 2024 and direct them to stay inside the police station of Diamond Harbour, my lord. But my lord,
Inside the police station, in the Thana?
Jurisdiction of...
Within the jurisdiction.
Well, there was no other condition. Just to stay inside, stay in the police station, stay within the jurisdiction, police station. But my lord, at least they should meet the IO once.
Very well. What is the stage?
No, my lord,
My lord, the stage is trial. Trial has charge has been framed. The next date is fixed. Yes, your lordship. The last matter and this was the similar matter. Connection similar.
My lord,
same case.
Same case.
Co-accused.
No, co-accused.
Then why? Riya Das.
My lord, she is suffering from cancer, my lord.
Where?
This petitioner is suffering from cancer, and I want to go to either Bombay or Madras for my treatment, my lord.
Why is the doctor?
I have attended already Tata Medical Cancer Hospital several occasions, my lord. In this period, my lord, by the release order was granted.
What document you have given?
So you have already went to Mumbai.
No, my lord. I want to go to Mumbai for my treatment, my lord.
So
At least should meet, or else the trial will
take
be.
the Rajarhat campus. Tata
Yes, my lord. Yes, my lord. Bombay earlier was way back, my lord. I am suffering from cancer, and at that time.
What medical document do we have here?
Hmm?
Medical document.
Yes, my lord. Annexure P2, page 10.
Page 10 not 14. Page
It's
10.
no-
Yes, sir.
Illegible.
No carcinoma present. Where?
Page 10, the P2 order is for
Have you gone through
14.
your document?
Page 14.
Page 14, my lord. Page 14.
Page 14. Page 14. What is the
Which portion of page 14?
Annexure P2, my lord.
Oof. Which part of? We are looking at page
it
14.
has been mentioned that he is a patient of carcinoma.
Cancer বলে কোথাও লেখা আছে?
Medical term carcinoma.
Carcinoma.
For cancer patient. Where? Where?
Cancer বলে কোথাও লেখা আছে?
We should reject. Come back with proper instruction. How can be done? Carcinoma patient.
কোথায় আছে না?
দিতে হবে কাছে।
Kidneys.
কোথায়?
Left TB junction.
Yes, sir.
Yes, my lord. Kindly page 15, my lord. Next page.
Yes. Where?
In both kidneys, my lord. Cancer in both kidneys.
No, something in both kidneys. No.
No stable condition in both kidneys. Left UB junction.
That means cancer.
Yes, my lord.
Calculus or something written there. Not
That you come back with better particulars, sir.
Yes,
Sorry.
my lord. Kindly.
No. We are rejecting this. There is no material on record. The petitioner was granted bail on June 26, 2024, inter alia on the condition that she will remain within the jurisdiction of the Diamond Harbour Police Station. Stop. She now wants waiver of that condition
Radiology.
on the ground that she is a cancer patient and needs to visit Bombay for treatment. Paragraph. We do not find any material on record which would indicate that she is suffering from carcinoma, that the petitioner is suffering from carcinoma. Stop. The two illegible documents which have been annexed do not support the aforesaid contention of the petitioner.
কোথায় লেখা আছে? কিছু তো লেখা নেই।
Paragraph. Accordingly, we are not inclined to allow this application. Stop. Dismissed. Paragraph. This will not prevent the petitioner from filing fresh application with proper supporting documents in support of her contention that she is suffering from cancer.
A report may be kept on.
yes.
Oh, report filed with the state be kept with the records. File করেছে কিছু state?
না আমি আপনাকে কি করে দেবো করতে পারবো Let's do that.
I appeal for the petition, my lord.
Not today.
My application, madam. This is the affidavit of service.
Yes.
State is not there.
Not today.
753, my lord, I'm appearing for the petitioner, my lord. My lord.
Day after tomorrow, my lord.
Yeah.
Great.
Appearing for the petitioner, my lord.
Madam, please tell the learned counsel, this is not fair. We are here, petitioner's advocate is here. Now, please tell everybody concerned, we are not going to wait for anybody. Ex parte, if petitioner is not there, dismiss. If state is not there, we'll proceed ex parte. Not today, not today. Next day, from next day, yes.
My lord, regards to 755 and 757, my lord, Mr. Dipanjan Dotto is appearing for the petitioner herein. My lord, what has happened? There is a bereavement in his family. My lord, his mother expired. I was humbly praying, can it be taken after 11th, my lord?
755 and 757.
7, my lord.
এটা তুমি করে দাও 16th.
16th, my lord. I'm deeply grateful. I'm deeply grateful. My lord is recording an order, my lord.
If you wish, we will.
My lord,
Rekho, actually 751, 750?
755 and 757.
Lekho. Accommodation is paid for on behalf of on behalf of petitioners learned counsel on the ground that there has been a bereavement, that learned counsel has suffered a bereavement, The paragraph as requested, comma, let this matter stand adjourned and be listed again on Sholo. Same order in 757. Appearance record করে না যদি স্টেটের কেউ থাকে জানি না।
I'm deeply grateful, my lord. হ্যাঁ দিয়ে দিচ্ছি।
756.
758.
Sixটা ডাকলে না।
হ্যাঁ 6 ডাকলে না।
Well, I am for the petitioner led by Mr. Vikas Bhattacharya. My lord, in this case, bail was granted on 5th September of 2024. Thereafter, after being released since 9th September, he has been complying with the conditions imposed on bail. My lord, very recently, the petitioner's wife underwent brain surgery. On 17th October, he has been released from hospital. And my lord, some personal cares are required. He is 64 years old. Petitioner is 64 years old. 74 years old, my lord.
At the time of getting bail, you may please release the accused on any condition. Now, within 2 months,
Well, I have complied with the
The
conditions.
difficulty is, my lord, the report says he was supposed to intimate the Chandrakona PS, the concerned PS, about where he is residing, and he was to visit once a week to the PS under which he is residing. That report I don't have, my lord. But Chandrakona PS says he has not intimated where he is
It was
residing.
not possibly required to intimate Chandrakona. If you
I
read
have
the order,
concerned
it said and shall provide the address where he shall reside
My lord.
to the officer in charge of the concerned police.
That report I have to bring.
That
where you are residing? Where you are residing now?
Kotwali, within Kotwali PS. My lord, I have annexed
got a
here
report
P3, page number 11. Kindly see, I have
in
annexed.
fact, day after tomorrow, he'll get the report in the
My
meantime. Get the report.
Your Lordship 758.
This report also may be kept
Your
on
Lordship,
record.
Your Lordship in 758. I'm appearing for the petitioner.
1 second, sir. 1 second.
Please.
What did you say?
No, this report also may be kept in the record.
তাহলে 756 একটা order করে নাও. Report filed by the state be kept with the records. Stop. Paragraph. However, we need to know whether or not the petitioner has been reporting to the Kotwali police station in terms of the order granting him bail. Stop. Let learned state advocate obtain such instruction. Stop. Please the matter once again on পরশু দিনের ডেটটা দিয়ে দাও.
Grateful.
758 I am paying for not to. Mr. Satyakant Gopal Mukherjee has been engaged in matter by PID as special counsel. Your Lordship, he has not come to court today.
Not today. Well, আর ফিরে গিয়ে কেউ আছে এখানে করার মতন মামলা?
I am for the petition in 758.
I'm 750. May I lead your lordship in this matter? If your lordship permit me.
আর
My colleague.
it has been adjourned for the day.
Your lordship, may I one more request. Your lordship, I'm not against the adjournment, but I have one prayer. The lordship is permit me. I have to amend the cause title. The respondent number 2 to 4 inadvertently have been made the parties herein. They are not a necessary party. In the meantime, I may be allowed to amend the cause title, your lordship.
Lekho. The petitioner says that the respondent numbers 2 to 4 have been added as a party parties inadvertently. Stop. They are not necessary parties. Stop. He seeks leave to strike out their names from the array of respondents. Stop. Such leave is granted.
Subject to the correction 2 to 5. 2 to 5.
2 to 4 na. Paragraph list this matter once again on day after tomorrow. It's true.
I'll go right time it will be. Yeah,